other videos I've put on there. I've put out a series of videos that are closer to 30 or 45 minutes in length, and they are really just kind of like one topic at a time, which is really kind of easy to digest. You can jump in and you can get a really strong understanding of exactly what we're looking at. If you have a question about post-closing occupancy, or if you have a question about due diligence, or any sort of writing a special stip, legal descriptions, if you really want just very specific non-CE information, you just want the information, you can go right onto the website. So it's a cool feature. And the best way that I can probably share that with you, if you searched on YouTube, you'd look for my name, Christian Ross, and you'd probably want to put in like Christian Ross Down and Dirty. Sounds ridiculous, but that is the name of this series. So you would find out a lot of different videos just by searching it that way. But let me see if I can share with you the link. I think that might be even better. I'll have to find that in a second. But email me also. So in the chat feature, I have put some information on these slides. We'll also put the information for registering for the CE credit, and I'll go over that in just 1 second. And then later on, when we take a break, I'll throw in some information on the YouTube channels in case you want to look at that stuff as well. Also, you'll see in the chat that my marketing director, Susie Barnhill, is kind of responding to some questions and giving you guys heads up on different things while I'm teaching the class. And if you have anything that you need from us, don't be strangers. Get familiar with us. Susie's one of the most amazing people I've ever worked with, and you should work with her too. She's just awesome. So definitely take a look at that. But why not get started? So let's see if I can unpause my screen. So this class, like I said, is brand new, writing a robust contract, and it was kind of granted from the scenario. Let me see if I can change this around just a little bit. So it was kind of built from the idea that sometimes this contract is not the right fit for everybody. So how do we change it, and how do we update it? How do we fix it just a little bit? How do we tweak it here or there? And the material is wonderful, but I know you also want to get your CE credit. So this is the requirements to do that. You'll register through Zoom. If you did, you would have gotten the invite to come into the class to join the link today. If you're sharing a computer, it probably won't work for you. You'll have to have separate logins and view it separately. And I know that's kind of frustrating, but just the way Zoom is tracking your attendance, it's only doing one user at a time. Also, make sure you're logged in for the full 3 hours. Don't shortchange yourself. Don't do 2.5 hours or 2 hours and 50 minutes. Do even if you can, do 3 hours and 5 minutes. So just to make sure you have enough time. And I'll keep the class open late as well. If you get kicked off for a moment, if you're having computer troubles or anything like that, just log right back in. And then finally, which I'll give you plenty of time to do this at the end, but complete a form for the application of CE credit. And there's a survey as well. And that's on our website, campbellbrandon.com/learn. So there's the information there. And as Susie said in the chat feature, that we'll give you plenty of opportunities to do that. We'll kind of teach you how to do it as well. All right, you should see everything. So here's kind of how I drafted the class. We have 3 sections. So the first one, we're going to talk about modifying seller remedies. And in order to modify seller remedies, we got to understand what the original remedies are, what the standard remedies are in the purchase and sale agreement. Once we get through that, after we take maybe a 10 or 15 minute break, we'll look at post-closing occupancy, because that is such in high demand. Sellers are requiring it on a lot of these deals right now. And, it's a double-edged sword. Obviously, I'd prefer you not to have to go that route. But in the event you do, how do you do it? How do you advise your client? What do you tell them are the ups and downs of going that route? Even from a seller's perspective, it sounds like it's only upside for a seller, but I'll give you a couple of scenarios where it wouldn't be. And then section 3, the last section, we'll do some repairs and amendment to address concerns. In fact, we'll touch on the right to request repairs, compare that to just a standard due diligence period. And I'll go against the current a little bit, and I'll tell you why a seller might prefer due diligence with a, the free look over a right to request repairs. It sounds counterintuitive, but I'll give you a few examples of why. And even more than that, I'll give you some suggestions on how to handle it and what the contract doesn't tell the client, and how to think about differently, because I think your clients, they hire you for a couple of reasons, and in turn, you guys hire us for a couple of reasons. They hire you for that just incredible customer service, the hand-holding, and the knowledge. You've done it so many times, and you have so many resources at your disposal that you can make this pretty seamless. You can make it straightforward. Well, let's make sure it's seamless. Let's make sure that everything is put together well. And then when you lean on me, you're asking me to be creative. You're asking me to give really good advice when there's just a sticky situation. So let's all lean on each other and make sure that we're going in the right direction. Again, before we get too much further in here, I know your brokerage does this a little bit differently, but we do not have any of your cameras on, and that is fine. That's perfect. You should only see my camera and my screen. And then Zoom is actually tracking your performance. So at the end of the class, it'll give me a report when you signed on, when you signed off. And again, if you get kicked off, just sign right back in. We'll be able to kind of put it all together, but I don't need your video camera to be turned on. And then, let's see, I think that answered that question. You do not need to check in, as Susie said. If you're on here, if you're seeing me, if you're seeing the chat feature, you're in, you're good. The only distinction would be is if you're sharing the computer, you probably need to go get 2 computers, something like that. All right, so let's start with section 1, modifying seller remedies, and we'll start with a question. So pop quiz, if there is a default, who has the right to sue? So the question, the answers would be, or possible answers, the seller, A, the B, the buyer, C, the brokers, D, B and or C, or E, all of the above. So maybe make a note, and then later on in the slides, we'll actually approach this, because I wrote this class a couple of weeks ago, and actually when I was reviewing this again, I kind of answered it wrong. So I'm curious, and be honest with yourselves, and I want you to put it in the chat later, but if you want to do that now, why don't we put it in the chat what you think the answer is. Terry's already said D. Terry says it's the buyer and the broker, and or the broker would have the right to sue. So go ahead. Michael says B. I just throw it in there. I want this to be more of a discussion. I want you to have fun with this, and I want you to throw yourself out there. Chances of getting at least one of these is right is pretty high. So Alexis, you said E as well. So we'll keep going. The basics of real estate contracts. So you got to start somewhere. What do we, when you call me, or you call an attorney, or you call your broker, and you're asking for advice on, well, what happens if, what happens when? We really have 3 pieces that fit into that answer. There's 3 things that I'm pulling from, and we're trying to distinguish between what the contract says, what the statute for Georgia or the federal government says, or maybe even local statutes might say. And then finally, case law, which is, well, there was a lawsuit a year ago on this topic, and this is what they said. So, and the case law is really meant to kind of blend contracts and statutes together. And so it's a complex answer. If you look at just the contract, it's pretty straightforward. You look at, section B 1A, you can read that. It's written, basically a 5th grade reading level. But what can be confusing, and what is really hard about this job in this industry, is that, well, now you have to compare section B1A to this statute and this lawsuit, or these 100 lawsuits, or something along those lines. And then you also have to look at other parts of the contract and how they all relate to each other. So your answers, that's where it really gets challenging. It's not in reading the contract, it's not in reading a statute or reading a case law, it's in blending all of them and coming up with an answer. And also for that reason, there's a lot of times it's not so black and white. If it is, that's great. And if it's not, I'll be the first to tell you, hey, there's nothing really on this, or this is kind of what it would be. Here's what I would suggest. So number 1, the basics of real estate contracts. State the terms of the purchase and sale agreement. So defining the agreement between the parties. That is rule number one. Have a conversation. And you may have heard me say this before, but the contract is essentially a conversation between the buyer, seller, and brokers. Think about that. It makes a lot of sense, actually. It's 10 pages long. Maybe it's 30 pages long because you have all these exhibits and contingencies and seller disclosures. Why is it so long? Well, it's hard to have all that, conversation just between parties. It's hard to put that in an email. It's hard to really cover everything. If we think of a couple of the things that are talked about in the contract, possession. Well, when am I moving in? When are you handing me the keys? It actually talks about it. It sounds silly, but we need that in there. What kind of warranty deed is the seller going to sign? Is it a quitclaim deed? Is it a limited warranty deed? Is it a general warranty deed? That needs to be in there. Well, what if there's an encroachment? That's in the contract. What if there's a fire and the house burns down? It's in the contract. It's called risk of loss. And then, other things. How do you define terms? And time is of the essence, or not. In some states, time is not of the essence. So it is truly a conversation, because 30 days later, when we're getting to the closing, you all show up here at the same time and you're fighting about, not that that would ever happen, but maybe there's a disagreement over a leak that the seller says they're not responsible for fixing. The buyer says, hey, yeah, you are. Who pays for this? How do we get closed? How do we get past this? And actually the contract, it's like, oh, by the way, we talked about this on day one in that purchase and sale agreement. We talked about this. If there's some damage to the property that wasn't there before, seller's got to have to replace it, repair it, bring it back to better standard than before. That's what this is. Hey guys, we talked about this. And seller, you told me you were going to fix it as long as, to the point where I got to bring it back to what it was when you made your original offer. Oh yeah, you're right. It's in the contract. So step one, we got to state the terms. We got to have a conversation. Step two, it determines the rights and responsibilities of all the parties, including the brokers, as issues evolve. So as those come up, who's responsible and who has to do what? It's setting rights and responsibilities on everybody. So, if we think about the loan contingency, the buyer has a responsibility to apply for a loan in a timely manner. They don't necessarily define what timely is, but I would assume within a couple of days of going binding, not 3 weeks later. So, hey, we talked about this, buyer, you said you were going to apply for that loan quickly. Now, I don't know what, that's what the conversation was. And then if you don't, well, what right does the seller have? The seller can put the buyer on notice that they're potentially in default. The buyer has to cure it. Then the seller, if they don't cure it, the seller can terminate. So in other words, the contract is meant to effectively communicate these rights and responsibilities in advance of them happening. But no contract is perfect. And in fact, we can't predict every scenario. We don't really want to. We don't really want to have to come up with an automated response to every possible issue, because automated responses are really ugly. And that kind of leads to one of my first suggestions to you guys. If you're rewriting the contract, if you're doing special steps, try to avoid automating a new price. And what I mean by that is, when we write all these escalation clauses, that's tough enough. Those are really brutal. But when we are modifying appraisal stipulations or language, some people are trying to automate this new lower price. That's really hard. That's really, really hard. I think the appraisal language was written for a certain reason. And when we start modifying it, making it automated, we start realizing how bad we are at writing these, and me included. It's really hard to do. So that's just my suggestion. But if you find a good way to write it and you give it to your spouse, you do what I call the spousal test, which is you give it to someone who has no context about the deal. They were not in the emails. They weren't on the phone. They just were like, they know how to read. Hey, does this make sense? And if it makes sense, then you're probably okay. But if it doesn't, we need to update it, because a lot of times we throw in stuff that's out of context in a bit. Terry and Al, everyone's starting to say E. We'll see. Elizabeth says E. It depends on who defaulted. Yeah, so keep answering. I love that you guys are enjoying it. Stephanie says A. Patricia says E. Sean says E. There's no problem with being wrong. So we look at this, it's contract versus the statute versus the case law. Our job is to best evaluate where these three forces are consistent and provide matching advice to help our clients. I think that makes sense. I think that makes sense. It's very hard to do sometimes, but the forms change. And this leads to one of not a huge pet peeve, but it's something I hear and I always respond to it. When I teach these classes, I'll give you an example. I teach a class and I'll talk about fiduciary duties. And some of the people that have been in this business a lot longer than me remember when it was the realtor's fiduciary duty. They had a fiduciary duty to their client to make sure that they were in good hands. Well, that may sound weird to the newer agents because that is no longer the standard. Fiduciary duty is an elevated duty to your client. And it means that you have to go out of your way to keep your client from doing harm to themselves financially. So you would, in a sense, if a realtor had a fiduciary duty and you thought that they were overpaying, you'd have to stop them. That's the weight of a fiduciary duty. If you're a fiduciary for someone, you have to get in the way, be like, nope, I can't let you do it. You're overpaying. We are not going under contract. That is a fiduciary. Think of yourself as like a trustee for a trust. You are doing all these things for the benefit of the trust, of the beneficiary, not for yourself, not, you're not, it's different. Whereas now, realtors have just a standard duty of care. And you'll look at your listing agreement, your brokerage agreements, and you'll notice you have a standard duty of care. You have to just do your best. And you can't be negligent in giving advice or things like that. You can't overstep your bounds. Basically standard duty of care. If they want to make a decision that harms them financially, they're allowed to. You don't have to get in the way. You just can't be a part of it. You can't necessarily make it worse. But 20 years ago, realtors did have a fiduciary duty. So if you were taught 20 years ago that, yes, you have a fiduciary duty, you have to do all these things to keep your client from doing harm and all that stuff, that may sound very, very foreign to you. And that leads to my point here. The forms and the rules that we work with change all the time. So one of my pet peeves is when someone says, well, that's not how I was taught. Well, think about it. How many times a year does the GAR contract change? At least twice a year they change it. They change it in January and then they change it in the summer. Last year, I think they changed it in May and then they changed it in August as well. So last year they had 3 different times when they were changing it. So we really just have to continue to progress. It's why you guys are all here. Continue to progress, continue to get better, take these classes, read the contract. Don't do it just because you were trained a certain way. Double check it. Does it still say what I was trained on back in 2018? Because 2018 is about, let's say it's 3 years ago. Contracts have changed 6 times since then. It's very different. COVID and all this other stuff that you may have heard of, this pandemic we're having. All of this stuff has come up. It really changes what we were taught. And so we have to continue to evolve. So the forms change due to feedback from realtors, balancing interests of buyers and sellers, requirements of changing law like TRID. 2015 or so, TRID came into, where we had to do closing disclosures, and it just changed, it put our whole world upside down from what we were used to, which I think it's done a good job actually. And then protect realtors from liability. GAR is working for you. That's a big thing. We notice something that people are getting themselves in trouble with, real estate agents, and we'll fix it. And so a calendar of committee meetings is available in the membership section of the GAR website. All members are welcome to join. It's actually a pretty neat forum. So I think it's like once a month on a Friday. I think they do it on purpose so that closing attorneys can't go. But once a month on a Friday, they have committee membership. They can go to these forum meetings, and you'll see people from all over the state come and say, hey, this happened and we'd like to see this changed. And some of the things we've seen recently have shown up on the GAR contract class. So how we deal with earnest money and who holds the earnest money. That's just one example of changes that we were required to do because of non-metro Atlanta areas, where maybe a lot of the brokerages did not have an escrow account, so they kind of made sure that that was in there. So I would reach out. They're kind of interesting, and you'll kind of learn why our contract is so convoluted and why it is the way it is and what changes are coming along the way. So let's go to that question initially. Who has rights to sue? So prior to August 2017, the GAR contract remedies read as follows. Rights of buyer or seller. A party defaulting under this agreement shall be liable for the default. The non-defaulting party may pursue any lawful remedy against the defaulting party. That's what it used to say. This is like page 3 or 4 of the contract, that basically buyer or seller can sue for whatever. They can sue for specific performance. They can sue for, damages, actual damages, punitive maybe. If the judge is going to grant it, they have the right to do it. This meant the seller had tremendous leverage in forcing a buyer to pay damages if found to be the defaulting party. This would often be limited to actual damages, which is like, hey, the seller was supposed to sell. In turn, it took them 3 more months, or, they had paid $20,000 in moving expenses, and now the buyer's not buying it. You have to reimburse them for the 20 plus attorney's fees. And sellers would use that. Sellers would absolutely use that to say, buyer, you've got to close. So I'm going to sue you. And it was pretty effective, but it also was kind of, unnecessary. It was a bit unnecessary because a lot of sellers, it was a lot of hot air, but they weren't actually suing. So actual damages are often known as real damages or compensatory damages. These are damages that arose from the neglect or mistake of another party. I always talk about leaving the seller at the altar. So we got all the way to closing. The seller moved out. They bought another house. They paid for the mover. They did whatever it may be. They fixed it, per the right amendment to address concerns. They fixed this item and that item and this item, and now the buyer won't close. So the seller says, well, I'm going to sue you. So example may have included additional rent, moving expenses, extra interest paid, repairs, etc. This likely did not include missed opportunities on investments. That would be, that's not real damages. So in 2017, mid-year 2017, the GAR purchase and sale agreement provided revised remedies to sellers and buyers upon breach of contract. So they updated it. So if the last time you took a class or looked at the remedies section was in January 2017, 4 years ago, you're way off, because let's look at it. This is our new default language. You notice what it was before, this really simple rights of buyer to seller. And now look at it. It's brutal. Susie says, one person said A, one said B, no one said C. D was 1 and E was 14. So that's good. Thank you, Susie. That's helpful. So remedies of seller. Seller's sole remedy shall be to retain the earnest money as full liquidated damages. The parties expressly agree that the earnest money is a reasonable pre-estimate of seller's actual damages, which damages the parties agree are difficult to ascertain. They are difficult to ascertain. Before contract, it's really hard to know what the seller's actual damages will be. So they put earnest money down. That's what it's meant to be. So what is it? What is the answer there? The seller does not have the right to sue. Okay, now we know. They can't threaten me with that. Remedies of buyer. So in the event this fails to close due to the seller, let's say the seller says, I'm not closing. Buyer may either seek the specific performance of this agreement or terminate this agreement upon notice of seller and holder, in which case the earnest money is going to be returned. So I really don't love the buyer remedies. It basically limits them to just suing to buy the house or getting their earnest money back. There's really nothing in between, which I don't think makes a whole lot of sense. I'd love for the buyer to have the ability to sue for anything, honestly. They want the house, great, let's give them the house. If they want to be reimbursed for their inspection and their appraisal and maybe extra rent or whatever it may be, I think they should be able to do that, but that's not what the contract says. And then if we keep going, the brokers, so you guys, if either the buyer or the seller defaults, the defaulting party shall pay as liquidated damages to every broker in this agreement the commission the broker would have received had the transaction closed. So If it was a buyer that said, I'm going to leave you at the altar, Mr. Seller, you can have the earnest money. So let's say it's a $500,000 deal. They have $5,000 down as earnest money. And then the broker says, well, what about me? Well, the broker can sue for the full 6%. You're representing the buyer. Maybe it's gone really south. And now Harry Norman says, we're suing the buyer. Not something we do often, but we're going to do it. Well, you can sue for 6%. Buyer's going to have to pay 30 grand to plus attorney's fees if it actually goes to court. And that would be pretty devastating to a buyer. They need to realize this, that, hey, once you sign on the dotted line, we got to be careful. We got to make sure that we are legitimate and we're moving towards closing. Attorney's fees, non-prevailing party shall be liable to the prevailing party, the winning party, for reasonable attorney's fees and expenses. So with this language, seller's sole remedy for a buyer's breach is to accept the earnest money as full liquidated damages. Prior to this change, the seller had the right to pursue any lawful remedy, such as suing the breaching buyer for specific performance and or the losses the seller incurred, which could include the difference between what they could have sold the home for to the buyer versus another person, seller's legal fees, all this different thing. In most cases, when a buyer breached the contract, though, the seller would just accept that and move forward. They'd take their earnest money, and earnest money has always been 1%. So the seller basically leaves with their tail between their legs. Fine, I'll just move on and sell it to somebody else. That was the realistic thing, unless it was a massive, $3 million deal, and the seller had some significant assets to go after someone in court. Most sellers just walked away. That's exactly what they would do. It's what a lot of brokers do too. So when they made this change to sellers just getting the earnest money, and that's it, they were hoping that earnest money would go up. Sellers would ask for more in earnest money as a result of this change. Unfortunately, that's just not the case. Most contracts are still really relying on that 1% of the purchase price. So per the legal counsel for GAR, there was a recent body of case law. This is the reason why they made this change, more than the practicality of it, which struck down the theory of being able to choose between earnest money as liquidated damages and any lawful remedy. According to that body of case law, if a liquidated damages clause is included in the contract, that is the seller's sole remedy. You could not choose one or the other as a seller. That it was basically illegal to have that in the contract. So it would be stricken from the contract entirely. So GAR said, well, if the courts aren't going to allow it, then let's lean on one or the other. Which one should it be? Well, let's take the bird in the hand. Let's take the earnest money. It's already been paid. It's not going to cost the seller as much money to go after. Maybe the earnest money amount will go up over time. Let's just take away the seller's right to sue. And that was wishful thinking, because as you all know, it just hasn't gone that direction. So buyer's remedy for seller's default, this changed as well, obviously. Buyer's remedy for seller's default shall be to sue for specific performance or terminate and get your earnest money back. In the past, the buyer could seek all lawful remedies, which could have included consequential damages, attorney's fees, extra moving expenses, rent during the holdover, all this other stuff, actual damages. So it limited what the buyer could go after as well. It basically was trying to prevent unnecessary lawsuits. We've got the brokers here. We already talked about this part. So here is our answer. B and or C is our answer. The seller, as we just went over, does not have the right to sue. It just doesn't. It's not allowed. There are very limited circumstances where the seller could even claim to have the right to sue. Maybe if there was never a contract or fraud or something along those lines. Maybe if we're not beholden to the contract itself, if there are other circumstances. But under the contract, only the buyer or the broker has the right to sue. The broker can sue for commissions as liquidated damages, and the buyer can sue for specific performance, but doesn't have to. Obviously, the broker doesn't have to as well. So unless modified, both the buyer and brokers have the right to sue. In no event does the seller have a right to sue. I think that's pretty straightforward. Who was the one, Susie, who was the one person that got it right? That's what I'm interested in. Now, I'll tell you, when I was reviewing this again, I think I got it wrong too, because I wasn't really thinking. But that's what it takes. It takes us thinking. It takes us reading it. We have to be careful. If we have a standard approach to how we advise our seller or our buyer, we need to write this part into it. Make sure that the seller knows, hey, if we take this deal and this earnest money, the buyer looks great. I think it's the best buyer on the Louise, very nice. So I think I would tell a seller, just so you know, we could get through all of our due diligence. We could get through the financing, the appraisal. And if the buyer doesn't close, the only remedy you have is the earnest money. And what we'll do is we'll take it and we'll put it right back on the market. Do you understand that? And they say, wow, oh my gosh. So, we could be moved out. We could have bought our other house already. And the buyer leaves us at the altar. Is 1% still enough? I don't think so. I don't think so. Keep that in mind, because no one really assumes that you're going to be left at the altar, but I'll give you a scenario. And the lift at the altar scenario it's actually very appropriate in this case. Buyers were engaged to be married, and they got through all their due diligence, all their contingencies, and the day before closing, they broke up. I'm not joking. The day before closing, they broke up, and they just said, hey, we're not closing. The seller was furious. Obviously, the buyer was heartbroken. I think the realities behind it were that because they were no longer to be buying it together, that the person who really wanted the house couldn't afford it by himself. So the buyer just simply didn't have the money to do it. He wasn't going to get the loan just by himself. And so the seller, as mad as he was, had no rights to sue. The only thing he got was earnest money. So let me go off on a little tangent here. I've used this a couple of times, and I don't want to have to use it ever again, but you would basically use, if you're representing the seller, use the threat of litigation by the broker to go after commissions to get your seller a little bit more money. So again, the scenario is $500,000 deal, $30,000 in commissions is at stake, earnest money is gone, the seller gets that. So we have two types of terminations. We have a unilateral termination, we have a mutual termination. On the mutual termination, it has a place for the brokers to sign. Can anyone think of why? Put it in the notes, if you would, in the chat feature. Why does the broker have to sign the mutual termination, but not the unilateral termination? Can you think of why? Consider what we just went over with remedies. Why does the broker have to sign off on a mutual termination? Maybe Luis Morgan will know. Maybe. Terry, you want to redeem yourself? Let's see, who wants to redeem themselves from their wrong answer before? There we go, Michael, you've redeemed yourself. Yeah, so Lynn, that's right too. So the brokers are basically waiving their right to sue. That's why the brokers have to sign off on it. So what you do, if you are really stuck and you really want to do a little bit more for your seller to hopefully, compensate them a little bit better, you reach out to the buyer's agent. You say, hey, look, we will sign a mutual termination and waive our right to sue for commissions if the buyer pays us an additional $5,000. And you just tell the buyer, hey, look, if you don't do this, you could get sued for 30. So this is a settlement offer. They don't want to have to sue you. It'd be expensive. It'd be silly. It'd be a bad look. They will settle for a portion. They will settle for a small piece, and it'll go all to the seller, and it'll be your way of saying, I'm sorry. It's worked. It's worked in the past. It's worked a couple of times, but I don't want to have to use that. I would rather you just have the extra earnest money initially. So you guys all redeemed yourself. You did very well. It's so that the brokers can waive their right to sue. That's why they're on there. It's not on the unilateral. On the unilateral, the buyer or the seller can sign that, and then we just have to deal with the earnest money. So what are our options? Our options, I gotta change that. If we were to, if we wish to modify the remedies clause, let's say your client, your seller, does not like the remedies clause. Let's say you don't like it. that one of your things, one of your value adds is that you talk about the remedies clause and you say, hey, look, at this price point, this is, an issue that we see a lot. There's not enough earnest money. They're not putting a ton down. So one option would be, let's carve out this remedies clause and rewrite it. And so I'll give you a couple of steps that you could write to replace those remedies clauses. And basically, I'm going to copy the original remedies clauses, and we're just going to use that instead. So in the event of default, buyer and seller are entitled to pursue any remedy permitted by Georgia law. This shall replace F201 C2 A through B, which is the remedies clause. And accordingly, the earnest money is not considered liquidated damages. I think that fixes that. Now, I really don't want you doing this for every closing, for every contract. I think this should be a one-off type thing for you. If you have a really persnickety client, I love that word. You have a very persnickety client and you need to be able to deliver a modified remedies clause to make them comfortable, make them feel like they can push their way through this and force the buyer to close. That's a good clause to put in there if you're really stuck on it. I think in some markets, in Buckhead, this might be more of a thing than in others. In Cobb, you'd be looked at, like you were a green alien. But in other markets, maybe it would be appropriate. Here's another one. Notwithstanding any other provision herein, seller and buyer have the right to pursue specific performance as a remedy in the event of any default under this agreement. This shall replace, and so that same language, replacing it and not considered liquidated damages. So this would be specifically allowing the buyer or the seller to sue for specific performance. Now, chat feature question, what is specific performance? We hear that catchphrase, that term a lot, and it's kind of a weird term. It doesn't make sense unless you've been taught what it is, unless you've read it. Go ahead. Michael, I'm going to answer your question, but everybody else, go ahead, hit the chat. So Michael asks, if you do this, what is the earnest money for? It's just damages. It's like a portion of the damages. So liquidated damages means that it's the full estimate of damages. It's everything. But when it's not liquidated damages, it's just a portion of that. So the seller or the buyer could go after more to cover, additional expenses. That's a really good question, actually. Thank you for asking that, Michael. So what is specific performance? Patricia is asked, but is earnest money mandatory? I would say earnest money is still mandatory. Yes. We're just talking about, is earnest money everything? Is that the whole amount of the remedies? Elizabeth says, do your duties. Specific performance, do your duties. Susie says, specific performance is to make the seller sell. Michael says, is making you complete the contract, actually purchase the property. Yeah, that's right. You guys nailed it. Very good. See how smart Susie is? Alexis says, specific acts of either party, buyer must buy, seller must sell. So you guys nailed it. That's perfect. You all know what it is. But let's be realistic. What they teach you in law school and what you'll see in case law, and actually I saw a legal memorandum written recently by an attorney who's very familiar in this topic in Georgia. And it said that, okay, maybe you can ask for specific performance, but actually getting it past a judge and the judge demanding the buyer buy the property is incredibly unrealistic. Because most of the time you just sell it to somebody else. What you really want is compensation, because my dollar bill is really no different from Susie Barnhill's dollar bill. It's just not. The seller just wants the money. They don't really care if you buy the house. Now, there might be circumstances where, in commercial settings or maybe land development, something where it's a little bit different, the circumstances are different. You could have a seller forcing a buyer to close. We used to put that in some of our land construction deals. We would do these big subdivisions, and I would force the builder to close for reasons just beyond money. And I think in those circumstances, when you have a very sophisticated buyer and a sophisticated seller, and everyone has lawyers, and that everyone agrees to this, like that they're educated about it, they're advised about it, they have counsel, then I could see a judge approving it. Yep, come on, there's no excuses. You're going to ruin this seller's business if you don't buy these lots. And that was agreed upon. You hired lawyers, you had very fancy law offices, all that stuff. That's realistic, but even then it would be a challenge, and you just don't see it very often. So those are some remedies. And again, I have the link to the slides in the chat feature. You can download these and copy the steps at any time. But if you've taken any of my classes recently, you know that I'm really a fan of option money. That's what I would love for you to do. And even maybe before you go down this, right, just get more earnest money. As you can see, this is complex. This requires the seller to really dig into it, a buyer. You kind of want them to be represented by lawyers in this case. You want them to have all the information, make an educated decision. You don't want that liability. But what you can do is just put more earnest money down. And this is not a bad thing. This really is not. Let's do our hypothetical again, the $500,000 deal. Let's assume the buyer is going to plan on putting 10% down. It's not a ton, but it's enough, right? We'll see that on a lot of deals, 10% down. So they've got a $50,000 down payment plus maybe $10,000 in closing costs. So they were going to come to closing with 60 grand. And how much are we normally asking for earnest money? 5 grand? I don't like that. In that same hypothetical, I don't see why a buyer can't put 20 grand down. And I don't think we should be offended by that. I think that should be very common. I think it makes your buyer look stronger. It's another tool in our toolbox when we're dealing on multiple offers scenario. Put 20 grand down as your earnest money. I know it sounds a lot. It's really not. Then the buyer's going to have to write another $40,000 check in a couple of weeks for closing. Yeah, obviously it would hurt if they can't close, but most likely they're not going to be closing for other reasons. And we have contingencies in place to protect against those things. So let's increase our earnest money. That's what we should have done back in 2017. We should have just started going from 1% to 2%. That would have been probably sufficient. I'd love for you to go for 5%, make 5% your start, settle on 3%. I also like to tell people that context is key. In Georgia, that sounds like a lot, but I'm originally from Florida where 10% is the standard. 10% wouldn't be that far off, right? That'd be 50 grand. That's a lot. Buyer's still going to have to come with money to closing. Buyer still needs another 10,000 for closing costs. So I know 10% is asking maybe too much. That's probably too much of a stretch for a lot of people just mentally to overcome, but 5% sounds reasonable, 25 grand, 4% would be 20. So Carol asked me to go through the option agreement, and that's what I'd like to do as well. And Andrea, we will put the link again. Just scroll up; it should be in there somewhere. And Susie, if you copy, I might actually have it. There it is. There you go. So here's option money. It's in the same section. It's section 8. This is page 1 of the purchase and sale agreement. And before we really get into it, if you've ever done a new construction contract, you'll notice that there's construction deposits. So in those contracts, you have earnest money and construction deposit. I'm going to throw it to the question, throw it to the audience here. Who pays what's the difference between construction deposit and earnest money? Who's it paid to? What is it supposed to be used for? All that stuff. Does it go into an escrow account? And so let's dig into the option money, and I'll come back to that question if anyone can answer that. If you've done a new construction recently, just tell me what construction deposit is supposed to be used for. Is it different than earnest money, and who does it go to? If you can answer any of those questions, that'd be awesome. Lynn, you nailed it. It goes directly to the builder. Now, does it go into an escrow account? What is it to be used for? It actually says it in the contract, so you don't have to know this off the top of your head. So Lynn says it does not go into an escrow account. That's right. The builder can use it to build the house. They can use it to pay for upgrades. In fact, that's what normally you'll see is that if you want an upgrade, if you want to add kitchen cabinetry to the basement, and it's going to be $30,000, that they'll make you write a $30,000 check payable to the builder as additional construction deposit so that the builder can go and order them. And after closing, maybe they install it, or maybe hopefully before. So option money is no different. It's paid directly to the seller, and it's non-refundable unless the seller were to default, which is pretty rare. Seller defaulting doesn't happen all that often. So due diligence period. So let's look at 8A, due diligence period. This is the part you always fill in, historically at least, maybe not this year. The property being sold subject to a due diligence period of blank days from the buying agreement date. Historically we'd see 10 days. Maybe it's 7, maybe it's 5, maybe it's 14, maybe it's 30. And then we always seem to ignore B. So 8B1. In consideration of seller granting buyer the option to terminate this agreement, buyer has paid seller, this is $10 in non-refundable option money, the receipt and sufficiency of which is hereby acknowledged. So they're basically, contract requires consideration. So this thing, for the right to have a due diligence period or for the right to terminate, you're paying $10 to get that option. You have that option. Then they say plus. Number 2, seller shall pay seller additional option money of blank by check, wire as of a certain date, and it's either applied toward the purchase price or it's not. So option money is paid directly to the seller. It's, for the most part, non-refundable. It's credited to the buyer at closing towards the purchase price. And if the buyer were to terminate later under a due diligence period or a sale contingency or a mortgage clause, something like that, the seller keeps that money. Even though they had the right to terminate, seller keeps that money. So if the seller never had the right to sue, seller does not have the right to sue. We went over that earlier. What's the difference between earnest money and option money? What does it change? That's right, Michael. The broker does not hold option money. The seller does. It's paid directly to the seller. But I guess my question would be, if under earnest money terms, if the buyer terminates, they're defaulting, the seller keeps the earnest money. Same thing for option money. Buyer terminates, seller keeps the option money. What's the difference between option money and earnest money? Why do I like option money so much? Carol says, yes, money is refundable, and you're stating option money is non-refundable. That's potentially the issue. The other thing I was thinking is brokers, right? So I don't mean to cut you out on this one, but it takes the broker being able to sue off the table. So we say, hey, look, you're past your contingencies and all of that. Or maybe you're not. Let's say we get to the contingencies and buyer terminates, earnest money goes back to buyer, option money wouldn't. It's non-refundable. That's the big difference, I guess. But even after that, the option money being paid already, I'm kind of swallowing my tongue a little bit, so I apologize. But basically what I see is that if you had earnest money with no due diligence period or option money with a due diligence period, the seller gets the money either way, right? So the buyer does their inspection, they hate it, it's not right, something's wrong, and they walk away. Well, if they did earnest money with no due diligence, seller's going to keep the earnest money, the buyer's defaulted. And if they terminate under a due diligence period, but the earnest money, option money is now option money, the seller still keeps the option money and the buyer's not in default, so the brokers can't sue for commission. So I think that's my difference, is that I'd love for your buyer to still have a due diligence period. I'd love for your buyer to have an appraisal contingency and then a financing contingency. I want your buyer to have all those normal protections. But I do think it's reasonable that a seller get compensated for being off the market for 3 weeks. So option money, let's pay the seller directly. Seller can pay for their mover. Seller can, pay their mortgage or get some of those repairs fixed. If the buyer's going to ask for $5,000 in repairs made to the property, well, give me $5,000 in option money and I'll go do it. Let's make it happen. So, and then Michael asks, explain the shall or shall not. So let's look at that. So again, buyer shall pay seller an additional option money of blank. That one's pretty straightforward. And then they tell you when. So you can either choose right now, or you could say it's due right after day 5. So maybe the buyer does their inspection, and as long as the inspection's right, they'll pay the option money. Any additional option money paid by buyer to seller shall or shall not go towards purchase price. Basically, is this going to be counted as earnest money or not? So if it's a $500,000 deal and they're going to give $5,000 as earnest money and $5,000 as option money, is that $5,000 option money part of the $500,000, or is it extra? Would the net price actually be $505,000? I would say most of the time, Michael, you're going to say shall. And it does say in parentheses, subject to lender approval. all that really means is, did the buyer write the check from a business account that's not part of the loan application, or did they write it from a personal account and it is? That's the difference. We'll see occasionally, in fact, it happened yesterday here at my office, where the lender did not allow the earnest money because it was written from a buyer's business account, which wasn't individual funds. It was like the lender looks at it as two different entities. So it wasn't allowed. So we had to reimburse the buyer for their earnest money, and then they had to come out of pocket with everything else. All right, Julie asked a great question. How much do you ask in option money? It depends. Let's do a couple scenarios. So one would be again, we'll use the same $500,000 deal, and we're going to do a $20,000 down, for earnest money / option money. You could split it. You could say, hey, seller, I'm going to put 10,000 as earnest money and 10,000 as option money. So if I back away, during my due diligence period, you get to keep the option money, 10 grand. You keep it. That was, for being off the market, giving me that due diligence period, allowing me to walk away, not get sued for commissions and all that stuff. You keep the 10 grand and I'll get my 10 grand earnest money back. I like that option, right? It's a lot of money down. Not really. We've already talked about that. Buyer loses a little bit, but gains a little bit. And if it was close, if, maybe this forces a buyer to move forward with the deal, which I think is good. When you go under contract and you spend money on due diligence, I want you to close. So buyer's got a little bit more in the skin in the game. Alternatively, you could do $20,000 option money. If, let's say it's multiple offers, 10 other people have already made an offer and you want to blow the seller out of the water. Hey, I'll give you 20 grand. I'll write you a check today to the seller. And even if I walk away later, you still get my 20 grand. Or you could use no option money. And the last part I always tell people, if the listing agent doesn't understand option money, then this is a waste, because a lot of times you're not going to be able to educate a listing agent who's looking at 10 other offers. Hey, this is why option money is so wonderful. This is why it's great. Don't go against the current. But if you call the listing agent and say, hey, would your seller be interested in me putting money down as option money instead of earnest money? And the seller says, yeah, we love that. Well, then you just hit something. They may really, really, really like that. So that's kind of what I would suggest. Nancy says, so are you saying one or the other, but not both? I think you could do both. I think you could. Let's say you have a property that's maybe a little lower in price. Say it's a $250,000 deal, first-time home buyer. They're getting a 3.5% down, 96.5% financing, FHA loan or something. And so now we're really tight on money. If we lose the whole earnest money or option money, it could really affect our ability to close anytime in the next 2 years. So in that scenario, you might put $2,500 as earnest money and $500 as option money, just a little something to the seller to say, hey, I'm trying here. I'm really trying. So you don't have to go all in. You can kind of hedge a little bit, but I don't know of any downside of doing both, Shubha. I really don't. I think it's something that is a benefit to a seller because it's money in their pocket, but to the buyer, it's no different because they got to pay that money either way. If they truly have the intention of closing, I love this for them. I really do. So here's a scenario: buyer makes an offer on a property, but has to compete with other offers with fewer contingencies. They need to level the playing field. How can we help them overcome and get under contract? Outside of raising your purchase price or eliminating contingencies, like getting rid of a sale or lease contingency. Last year, we would see that. This year, you'd be crazy to put a sale or lease contingency, right? It's wild how quickly things change. I would recommend a buyer seriously consider using option money. So the background on this form is that it was actually added, I don't know, 5 or 10 years ago, because there were a lot of people making offers sight unseen, and the sellers were getting frustrated with like, hey, you're not even coming to see this property. You have no skin in the game, especially if you have a due diligence period. Show me some money. But no one actually used it. No one really used it until now. I think I am seeing a lot more people use option money. So as I talked about, we got to put in the amount. So if it's $10,000 of earnest money, you could do 5,000 earnest money and 5,000 option money. Timing, just realize that whenever the option money is paid, it's not coming back. So if you can push out that date, if you can say, it's due on day 6, and on day 4 you're going to do an inspection, or you're going to do another walkthrough or something. You might be able to, you wouldn't have to pay the option money if you find something you don't like. And then credit to purchase price. So I'd say almost all the time you're going to see it getting credited towards the purchase price. So you would check that shall. Shall not means the price is actually higher. That's right, Michael. So you've got, this was almost like just separate compensation. And so now you're going to have to come up with another $5,000. So instead of 500,000, it's basically 505,000. You've got it right, Michael. So ultimately use this to either elevate yourself in the priority of other offers, or to incentivize, aka compensate, a seller for accepting a long contingency. So when I first saw this in the contracts, I thought, well, 60 days of sale or lease contingency, and then if the buyer's home doesn't sell, the buyer gets to terminate, get all their money back, and seller gets nothing. That sounds awful. So that's kind of where this all started when I started using this, was basically to compensate the seller. Hey, thank you for taking your house off the market. Thank you for taking my offer. Give me a couple of weeks. I'll make sure that this is the right one for me, and then we'll close. But if not, you at least have some money to pay for the moving, to pay for the repairs, pay for, basically being off the market. Continuing the example above, a buyer really wants the seller to accept their offer. Faced with removing a financing appraisal contingency, removing the sale contingency, the option money might be much safer. So seller is guaranteed payment of the option money, and the buyer gets the deal. And if they have to terminate later, they are not going to be defaulting. They would actually have the right to terminate under a contingency. So an option obligates the seller, but not the buyer. The buyer has the right to purchase the property, but does not have to. And that's just kind of general, the definition of option money. That's a really interesting topic. It's a lot of fun, actually, and I hope you guys enjoyed this first section. Just to remind you, you're all registered already. If you're here, and just stay logged in. We're going to take a little break, but overall, stay throughout the whole class. If you leave early, I'm not going to be able to give you credit. So minimum 180 minutes total from the time you sign in to the time you sign off. And complete the form on my website. So I'm going to put the link to the website right now, campbellandbrannon.com/learn. And in fact, why don't I show you how that works? If I can. New share, okay. So Campbell and Brannon, you have to do /learn. Tried to make it easy, oops. /learn. So you'll come to our website, looks like a normal one, but if you scroll down, writing a robust contract, you'll put in your name, I'll put in mine, license number, email. By the way, here's my email, cross@cb.law. Feel free to email me for anything that you may need. And then just go down here, tell us how we did. Tell us we were the most wonderful thing. I've tried to automate it to all be strongly agree, but for some reason the system won't let me. So I'll just have to trust you. But give me some feedback, because I do read these things. If there's something that you were struggling with or that needed to be clear, just let me know. Or if there are classes you'd like next time, just that would be helpful too. You'll push submit. You should get a confirmation email. And the behind the scenes, give me some time. We've got a lot of people on this class today. We've got over 60 people. So it's going to take me a minute to get everything registered with Greg, probably a week or so. But if after that you still haven't seen it, you feel free to reach out to me. But Susie and I will reach out to you if there are any sort of missing pieces on your application, and we'll make sure that you get it. So why don't I sign off for the moment? Sorry, this is the screen. I think you can see it now. So it's campbellandbrannon.com/learn. So we're going to take a 15-minute break. We'll come back at 11:15. I'll try and answer some more questions either in the break or when we come back. But 11:15, we'll come on back. So answer your phone calls, do all those things, and then I'll see you shortly. Thanks, guys. All right, guys, I hope that you took some time to rest, to take your break, because hopefully section 2 will be even more fun. And this is something that I think has a lot of applicability in today's market, is these post-closing occupancy by the seller. Very rarely you would see a buyer requesting pre-closing occupancy, so we probably won't touch on that, but the same principles would probably apply. Going back to a couple of questions that were asked before, Blair says, if both parties agree on none, I assume this is allowed. I asked because I've actually done this before. So he's regarding earnest money. So I have seen several contracts where there's no earnest money stated. You might see this when the seller is probably less sophisticated, or it's a weird deal, or maybe the buyer is going to do a lot of due diligence, and so it's really unnecessary to have all this earnest money tied up. But I would say, for the most part, in our standards, you're going to see earnest money, and because if we're using a GAR contract, that's the seller's only remedy. If you put 0 and the buyer defaults or doesn't close or whatever, the seller gets nothing. And if that's enough, that's fine, but it probably needs to be addressed that in that case, the seller has remedies to sue and go after damages. I really wouldn't advise you having no earnest money and no remedies as a seller, because what's the point? But yeah, Blair's right. I have seen it. I see it a lot on like wholesale deals, or where you have a sophisticated seller and a not so sophisticated, or not sophisticated seller, but a sophisticated buyer. And they're almost taking advantage of the situation. So his question ultimately was, is it illegal to not have earnest money? And it is probably not illegal, but you need to have some sort of consideration. What does the seller get by going under contract? And it doesn't have to be much, $250, $500, $1,000, whatever it is. It doesn't have to be much, but 0, it kind of offends my senses, if that's even possible. So hopefully that helps you, Blair. So this is section 2, post-closing occupancy and sale or leaseback. And this goes again to what we talked about initially in the first section, which is, I have a couple of these pet peeves, and one of them is, I think there was a time where it was taught that post-closing occupancy or temporary occupancy is not the same as a lease, that you're not technically a tenant, you're not technically a landlord. And I'll just set the record straight, they're the same thing. They're the exact same thing. There's some arguments that, hey, the temporary occupancy agreement doesn't have to be approved by the HOA because it's not technically a lease. And I don't think that's realistic. I just wouldn't ask the HOA. The HOA doesn't know, it's the seller. He's been living there for 30 years. Why would he have to apply for a lease permit for 30 days or for 10 days? I mean, the form that we use is almost irrelevant in regards to whether it's a tenant and a landlord, because if you have someone living there who has possession, right of possession, exclusive right of possession, and they don't own the property, they are a tenant. They could be a tenant at sufferance, a tenant at will, but they are a tenant regardless. And if you are the owner and you have given someone else the right to possess the property, to occupy it, you are a landlord. You can call yourself whatever you want, but you're a landlord in the simple definition of things. So that's the most important part, that you have to understand what is actually going on. Don't let the forms or the terms or what someone else has trained you, even what I've trained you, just make common sense out of this. Tenant, landlord, what are the risks? And where this usually starts, when someone usually calls me about this, the question is, my client is worried about X. And that should be a red flag for you. Okay, if my client is worried about it, what's the best I can do for them? And the best that you can do for your client who's worried about being a tenant or being a landlord is sign a lease. Do an actual lease, because that one-page temporary occupancy agreement is pretty bad. It is one page. It does not have, we talked in the first section about having a conversation between the parties, and, our contract might be 10, 20, 30 pages. Well, 1-page document is a pretty short conversation. That's one phone call. We hit 5, 10 different points, and then we jump off the phone. Yep, we've covered everything. Not exactly. There's no move-in checklist, there's no move-out checklist, there's no security deposit. Payment is not included on the temporary occupancy agreement. All these things are deficiencies in my mind, because what it does is it sets up unrealistic expectations. It makes the seller feel like they're not a tenant, that they shouldn't have to pay earnest money or security deposit, that if something breaks, it's not really my fault. It's the seller's property. I'm just staying here. I'm just keeping my stuff here, whatever it may be. They're pretty different. Shuba says, what if the rental limit has reached for the community? Can we still do a temporary occupancy agreement? I just wouldn't ask. And I think that may go against what you hear from a lot of lawyers, but I think you're only going to invite problems if we ask for permission, some sort of hardship waiver or a lease permit. The condo association is just going to say no. They will say no. But the only way the condo knows is if you ask. So we've got the same seller continuing to live in the property for a couple of weeks after closing, getting their stuff out, they're moving out, there might be a U-Haul truck. Don't ask for permission. It's not really necessary. This is a temporary thing. It's not truly, a new tenant and someone that the HOA doesn't know about. This is someone the HOA knows about. They have their cars on record. They have, their history of payments. They have all this stuff. The owner, or now the seller, the tenant, knows the rules, knows the regulations. They know all this stuff. So probably not necessary to get the HOA's approval. Stephanie says, on another note, I have had the sellers move out pre-closing and the deal fell through a day before. My sellers were furious they hadn't moved out. And we talked about that in the first section, Stephanie. That's being left at the altar. That's awful. I had one of the hardest deals, not the hardest, but one of them was a $2 million sale. This gorgeous property, gorgeous. It was somewhere out in the where there was some acreage. It was a beautiful home. This guy had slaved over this home for 10, 20 years, something like that. It was a labor of love, but he was done. He was ready to sell and had been on the market for a minute. He got a good offer, not a great offer, but he took it. And the buyer put down $20,000 maybe, which seems like a lot, but it was a $2 million sale. So it was still only 1%. The seller, it was supposed to be all cash. The seller moves out. I think the seller probably spent 50 grand just moving out of the property. And he signs everything. And guess who doesn't sign? That we got every excuse under the sun as to where the money is and where's the buyer and what about now and what about next week. The only thing we never got was an actual closing. That just never happened. It was really frustrating to the seller. And he went the route that we were talking earlier in the first section, which was, he actually had the broker sue for commissions. Said, hey, broker, you sue for commissions just to get some leverage. Let's get this buyer to do something. And that's what the broker did. And on a $2 million deal, that's pretty significant. That was a $120,000 lawsuit with attorney's fees and all that. That's a big deal. So keep that in mind. And then Shuba also asks, is there a max number of days for temporary occupancy? Technically, no. You could use that temporary occupancy form for 10 years if you wanted. But there are some restrictions, and we're going to go over that. And then I have more practical advice for you that we'll talk about as well. So aren't Georgians nice? When I moved here, that was kind of how temporary occupancy was defined, is that, wow, Georgians are just as kind, and tradition, give the buyer, give the seller a couple days to move out. Just let's be nice about it. So due to the difficulty in coordinating selling / buying / moving, it was not uncommon. It is not uncommon for the seller to negotiate a lease back. This provided for the seller to ensure the property was sold before officially moving and to potentially prevent having to store furniture pending their purchase. More importantly, it was like a hedge, or like almost like a loan, where it's like, hey, let's close, and that way I can buy my house on Monday. So we'll close on Friday. I'll close on my new home on Monday. Give me the weekend to start moving out, and by Tuesday, it's all yours. So best case scenario, not needing it due to the liability involved with leasing and or being a landlord. Sellers who have already purchased a new house should be encouraged to avoid asking for this. And there is no better time to take that advice than right now. You are not letting your seller down by not requiring they get some sort of time in the property. You know, if you're worried about having expenses for moving and then not sell the house and have to reset staging, let's say you paid $5,000 to stage the property. Your seller's already moved out. They've bought something else. It's not a financial thing necessarily, but if this buyer doesn't go through, well, the staging is going to be taken away and we'd have to put it all back just to get it back on the market. That's a problem. I don't want that expense. Ask enough money for earnest money or option money, right? Make sure that whatever option money you're asking for, earnest money, includes the amount needed to restage. That's a much simpler thing than, hey, let's get a couple days to move out after closing so we don't have to restage it. And so here's the scenarios that came up recently. I've had a couple of deals where the seller asked for time after closing so that because they could, and sometimes you see 30 to 60 days, it's not uncommon, but I'll warn you, that's a long time. 30 to 60 days is a long time. So I had a call from an agent, deal's already closed. The listing agent worked his tail off to get this deal done, fielding all these offers. He earned his commission, but the seller is staying in the property and things happen, things break. There was a leak in one of the upstairs bathrooms. And now the seller is calling panic to the agent saying, hey, what do I do now that there's this, and who pays for it, and what should I do? And then he has to turn around and call me. And it was just this like whole extra thing. The seller did not need to do this. The seller should have found a way to move out, moved in with her parents. You know, it doesn't cost very much to put stuff in storage for a couple of weeks. It's almost like this false sense of security because it's really not. If something were to break, and here's what we ended up having to deal with. Something breaks. There was a leak in the bathtub, and the seller's like, well, what do I do? Well, let me challenge you on something. Is this something that should have been disclosed to the buyer originally? Or is this a brand new thing? If it's a brand new thing, did you cause it? Or was it just wear and tear? How do we prove that? How is a bathroom leak wear and tear? That doesn't make a whole lot of sense. So the seller's in a bad spot. Now, you know, it doesn't look so free anymore. They've already had to reach out to an attorney. It's not getting free for them. What I recommended was fix it. Fix it, you know, have a plumber come out, have them diagnose the issue. If it's a couple $100, hopefully that's enough. Hopefully that's it. Get it fixed, get a bill paid, invoice, and then give it to the buyer and say, hey, this happened. You know, I got it fixed and got it cleaned. Here was the cause. Sorry for the inconvenience, but let me know if you have any questions. That's great. That way we don't have any sort of, you know, should this have been disclosed or was this wear and tear? That's just the seller saying, you know what, we got to do this. And she did. She was lovely about it. And that's exactly what happened. It was great. But I told her, I said, if this is a big issue, if like the tub cracked and now it needs to be replaced and it's going to cost $8,000 to replace everything and retile it. Yikes. Yikes. I honestly don't know because it's maybe wear and tear, but is this really the first time? Was it damaged by the seller? I don't know. That's tough. And maybe you have to hire a lawyer, or maybe now the seller's coming out of pocket a lot. That's a really problem. But if they need it, do they really need it? Let's find out how to use it. Let me look at some of these questions here. Elizabeth says, do you guys see the case in California where seller, oh, I did see this. Seller has refused to move out when in fact the buyer's paid over $500,000 cash, and after closing the seller did not give up the keys. And as of this point, the seller is still in there and the house closed in January of last year. Oh my God. And they can't get them out. Yeah, I did see this. And the article that I read said that this has happened a couple of times throughout the country. Now, the thing that was unique about this scenario is the seller did it on purpose. The seller knew that this was going to be an impossible task for the buyer. In fact, I didn't know if they paid cash for it. I had assumed they had gotten a mortgage. Maybe I was wrong. And the mortgage thing scares me more because, 30 days, 60 days, maybe there's not a mortgage payment, but then there starts to be. So if you've paid a mortgage payment and now you're having to pay a lease and you're paying lawyers to get this guy out there, it's just awful. In the meantime, you think the seller's taking care of the house. You think he's cleaning the floors and fixing the plumbing. No, if something breaks in the bathroom, he just uses a different bathroom. It's really, really bad. And there really hasn't been an eviction all year, except for in like extreme cases. So yeah, that's bad. And imagine how you would feel if you were the buyer's agent or the seller's agent, right? So you're the seller's agent. You didn't know the guy was going to do this. You had no clue. He didn't warn you. Well, you're probably getting sued just like he is. And it's not fair and probably not right, but they can't help it because the buyer's getting screwed. It's really, really, really bad. Yeah, that's a crazy article. And I'm not surprised. That's a seller who's probably too smart for his own good. Now, what I will tell you is, he's going to have a problem at some point. His time will come when he's got to pay the piper. He made money on the sale. He's got cash or whatever he's doing, unless he's going to go bankruptcy or just spend it or like it's, he's going to have to pay the piper. It may not be right away, but it will come. And so that's my only hope, is that I would put the fear of God in the seller and say, hey, you may be getting away with this short term, long term, you are screwed. You are never going to be able to lease another property the rest of your life with a situation like this. So I hope that gets resolved, because I don't want that to ever happen. Debbie says, and she's correct, mortgage company won't let the seller occupancy for more than 60 days. We'll go over that in a second. Stephanie says it was a hidden defect. It could have been. Seller may have needed to disclose that. Lynn says the seller should get insurance for this temporary occupancy. Maybe. The buyer is going to have the property insured. It's the buyer's house. It's all of this stuff, right? So the buyer knows at the end of the day, if this seller doesn't fix it, it's going to lie on them, even if it's not right, even if it's not their fault. It is going to be their problem. The buyer is ultimately going to be responsible because it's their house. So luckily, in most cases, the buyer is going to have homeowners insurance and they'll be okay. Let's keep looking at this. Buyers, pros and cons for post-closing occupancy. The pros, this could win you the deal. And that's it. That is the only pro. So though this changes frequently, a buyer competing to purchase the property could use this to secure the deal. Why wouldn't a seller be enticed? And other positives, well, there aren't any. That you can only go downhill from there. So here are some cons. Hard for the buyer to do an official walkthrough once the seller moves the furniture out. So, you're going to do your walkthrough the day before, and the seller's stuff is all still there. They haven't taken anything down. They haven't moved anything out. It's difficult to know what state the seller is going to leave the property in. You're taking a risk. You're hoping that the seller is legitimate. And most of the time we find out during the contract that the seller is very legitimate and ethical, and they're going to do the right thing. But when you go under contract initially, you don't have that information, especially if the listing agent is inexperienced, someone you've never met before. You don't know. You have no idea, and your buyer doesn't know either. All of a sudden, the buyer's a landlord. That's not fun. 2 B's. It was so good. I did it twice. Little security in the event of damage to the property. That's true, because that temporary occupancy form does not have security deposit listed on there. You'd have to add it in, which a lot of times we don't. Failure of the seller to vacate is a very real risk. That is true. Let's see if I can update this while I've got it. Look at that. Perfect. All right. Seller pros and cons. Obviously, there are a lot more pros for a seller. So the main positive for a seller is the flexibility afforded with not having to move out by the closing date. This can avoid excess interest payments, storage fees, moving expenses, and short-term rental costs, especially in the fact that if the buyer's not going to close. So if you weren't expecting to be moved out for closing anyways, and the buyer all of a sudden doesn't close, the seller's not really as upset. They're probably still angry, but at least they haven't moved everything out. At least they haven't gotten rid of the staging. At least they haven't done all that stuff. The cons, though, not always the case. There's typically a cost, even if not an exact dollar amount. In my scenario where there was that leak, that's a cost. For example, a buyer may be willing to give the seller 5 days after closing to hand over possession, but in return insisted the seller deep clean the property or give a credit to the buyer at closing. It's maybe it's all part of the contract. Maybe the seller could have asked for $1,000 more. There is a cost. It is not free, and I think our sellers need to know that, and we should use that to try and push them to see, is there any other options other than staying in the property, because it extends your job. I don't think you're getting paid enough to babysit this after closing. You need to be able to move on. You need to be able to work with other buyers and sellers. You need to have the seller find a new place to live. You need to use this to leverage, in your case, to promote, a seller moving forward instead of going backwards or staying stable. So obviously we talked about the two options. You got your temporary occupancy form and you got your lease. So F219 is temporary occupancy. And this goes to one of the questions that was earlier. What do I recommend? Well, like I said, you could do temporary occupancy for as long as you want, but personally, I would say anything less than 2 weeks. Obviously, you're asking a lawyer this question, and I'm only thinking about downside. That's how I'm trained. So you're not, I don't have any other context. I'm just saying, hey, I've seen it go bad so many times that I really want you to use the lease, but I get it. I'm going to try and be practical. I mean, if it was a perfect world, I'd say a lease on anything more than a day, right? But I know that's not practical. Temporary occupancy form is just so much easier to use. You could put a stip that says buyer has the option to require the seller sign a lease or a temporary occupancy agreement at any time prior to closing. You could do that. You could give the buyer the option, but I think it's better, less is best. It's very easy to execute. But the downside is it lacks a security deposit, it lacks rent, who the occupants are, prohibitions on smoking and subletting. It doesn't say they can't sublet the property. They can't list it on Airbnb for the weekend. And again, this is not a loophole from lease restrictions. This doesn't solve it all of a sudden. This is, that lease restriction is still something we've got to deal with. And so F913, your brokerage has a wonderful leasing program and a whole department. Tia Miller, she's lovely, just dealing with leases. So, you go this route and you have questions, you haven't done one before, you got to reach out to her or myself. But this is for more longer duration. Let's say we're doing it for a month. They've got the month of April to stay in the property, and then they're going to move out. It is more difficult to execute. I counted it. It's 12 pages. That's kind of annoying. But it's preferred in any circumstance. It really is, because it talks about smoking. It talks about who the guests are, who's allowed to live there and who's not, pets, all that stuff. So practically speaking, this can occasionally overcomplicate a transaction. That's the downside, is if you ask an attorney's advice and I tell you that you should use a lease, leases are a pain in the neck to draft. They're not terrible because it's still a form, but it tends to bring up more questions, which is the whole point. It's supposed to bring up more conversation. So this is Fannie Mae, Freddie Mac, and FHA. They all require buyers to move into a financed property within 60 days of close. This is what Debbie was saying. And this is directly from the borrow occupancy and financial affidavit, which is signed at closing. So any buyer that's getting a mortgage has to sign this form. It says buyer either currently occupies or uses the property as borrower's principal residence, or borrower will occupy within 60 days after borrower signs the security instrument. So within 60 days of closing. Unless lender consents in writing otherwise, borrower will continue to occupy and use the property for at least a year from the date of closing, after which the buyer could rent it out or do whatever they want. But they're making the buyer swear to this. So if you agree to something that's longer than 60 days, or if you later change it, they have violated their loan agreement with the lender. That's not good. They have committed mortgage fraud. Everyone always asks, how do you commit mortgage fraud? What does that even mean? Well, this is one way. If you do it for longer than 60 days, or if the buyer later changes his mind, they are committing mortgage fraud. the more you know. I've always wanted to use that decal. So some mortgage lenders have overlays, which are additional restrictions over just what standard Fannie Mae and Freddie Mac would require. So in this case, you might see a 30-day limit because there's an overlay. So as a reminder, an overlay is an additional requirement or rule that a lender will add on top of the Fannie Mae Freddie Mac guidelines. So Fannie Mae Freddie Mac may say 60 days, but this particular lender, let's say it's Prosperity, for example, they say, hey, for whatever reason, their new underwriting guidelines say they have a 30-day limit because we're seeing underwriting issues in those scenarios. So assuming even taking what I say at this class, you really have to ask the lender. You have to verify, hey, this is what we intend on doing. Do you see any issues with that? Neil asks, can you ask for money to be held in escrow until they leave, and have you done a walkthrough? So yeah, you can, Neil, but it's hard to do that under the temporary occupancy agreement because it just doesn't account for security deposits and what you would need to find on a walkthrough. So Neil, let's think of a scenario. Let's say it's 60 days, the max we can do. You sign a lease and you have a move-in inspection. So at the time of closing, this is what the property looked like. There were no stains in the bathroom. There were no stains in the living room. The drywall was all intact, all that stuff. And maybe just take pictures, maybe something super simple. All the appliances were working. And then 60 days later, when they go to move out and you do your walk-through inspection, your checkout inspection, and you notice that now there's a big stain in the living room, you need to be able to compare the two and follow Georgia law on releasing security deposits or withholding security deposits. It's pretty complex. It's really a lease. And we've oversimplified it, but to our own detriment. So you are all advised that temporary occupancy agreement is not perfect. And so it goes back to my initial point, which was, if you have a client say, hey, I'm worried about this lease thing, what about this? They start asking questions and started picking apart that form. That should be a red flag that we need to use a lease. We need to take this very seriously, because you'd never want your client to come after the fact and say, hey, I said this was going to be a problem and you shushed me. One of the benefits of being married to my wife that I've found is that I can't just yes her to death. I can't just say it's going to be okay, don't worry about it, because that's not how she operates. She wants factual answers. And if I don't know, I need to say I don't know. So if you have a client that's similar to that, which hopefully you do, that won't just accept you yesing them, we need to have a good answer. Okay, I'm listening. You say you're a little nervous about this seller. You don't know who the seller is. You don't know how to verify walkthrough versus when they move out. What if something breaks? Well, let's do a lease. That way, everything is laid out. We have a more thorough conversation, more thorough contract with what is the expectations. So here's a war story, and you may have heard this before, but this happened to me a couple of years ago, and I'll never forget it because it was very realistic. It was very reasonable as to what happened. So after closing and subject to post-closing occupancy, the seller's adult children moved back in for the summer and brought their dogs. Yikes. The buyers, having just recently closed on a $1 million property, were highly annoyed when they found this out and immediately asked what remedies they might have to kick the sellers out sooner. So think of that. The buyer just spent $1 million. And I think in that case, it might even been cash. They're expecting a beautiful home. So $1 million, the sellers negotiated 30 days or 60 days, whatever it was. And it was during the summer, the seller needed time to find the next place, whatever it was. Maybe they were planning on the kids moving back and they didn't want to upset the apple cart in the time, but the buyer didn't know that. That was what was negotiated. Well, there were no restrictions on the adult children coming and living there. There were no restrictions on pets. There were restrictions on parties. In fact, I think they threw out a big party like that first weekend that they came back, and the buyers, it just made it worse. It was like adding fuel to the fire. It was brutal. So unfortunately, they'd only signed F-219, and the sellers were not contractually restricted from letting their kids move in, bringing new pets, smoking on the property, even subletting the property to other parties. There was no restrictions. It just said they had the right to occupy. Luckily, the sellers behaved themselves for the remaining 45 days and vacated without further incident. But it was not fun in the meantime. The buyer was freaked out. The agent probably felt like she wasn't doing enough or hadn't done enough, and man, I had no idea. They didn't warn me about this. But it was a war story because, in hindsight, what should we have done? Well, this is a significant amount of time. The sellers looked reasonable. There were no pets. They kept good care of the house. It was a very expensive property. It didn't seem like it would be something we'd have to worry about. But it was almost like, hey, now it's not ours. And kids are here one last time. Let's blow it out. Let's have a big party. And the buyers were just super annoyed by this. They felt very disrespected. Andrew says, under temporary occupancy, can the seller pay per diem amount? Can we write a special stip for that? Used to be a place to do this in the temporary occupancy exhibit. There's still a place for this, but it's only for after the time period. So it's for a holdover tenant. So let's say the 45 days goes and the seller still doesn't move out. There's the space where you could put $150 or $500 or $1,000 a day, but that only starts at the end. And then Andrew, yeah, a lot of people will put a stip in there, but now we're writing contract. Now you're giving legal advice. I don't like that. If we're going to start throwing in rent and security deposits, let's do a lease. I know it's a lot of work, but let's do a lease. Otherwise we got to put it into the contract that, like, let's net it out. I just want to tell my seller, hey, look, seller, you were offered 500,000, but now you're asking for 2 months to rent it back. You either pay 5,000 a month and you pay it right up front, right at closing, or let's just reduce the price to 490. Save the buyer a little bit of money, and get it all part of the deal. And then you don't have to pay actual rent. That's an option. It's a good option. So bad tenant, anyone can collect rent, but not everyone understands the potential risk that can come with renting your property. It's your property, demand the best. If this was for you, what would you expect? And if you're on the other side, if you're the seller, or you're representing the seller, just warn them what this is like. Hey, you're going to be a tenant. And if something breaks, you might have to fix it. You're in a weird spot. So, unless you are super confident you need this and there's no other options, I really, really wouldn't recommend more than a couple of days. But, if you are going to ask it, just realize it's not a perfect situation being a tenant or being a landlord. We don't know who this buyer really is. We just don't. I should have had another picture that did the exact same thing and said bad landlord. Because I think that applies in the same sense. So we've done all this stuff, and the situation that comes up in the chat feature where the seller stays beyond the time period, they're a holdover tenant or a tenant at sufferance. How do we get rid of this person? And this is just like a really quick and dirty portion of a class that I've actually taught specifically on leases, but the same applies whether it's temporary occupancy, a couple days or a couple months or a couple of years. And here's the options. So mutually terminate the lease. If the lease is nearly up and the tenant is planning to move in with family, or facilitate that by allowing them out the lease early and releasing the security deposit. All right, let's see if we can do this together. What is the issue? Seller wants to leave early. Is there any money that I can get for leaving early? I already paid. Can I get a discount? Yeah, let's work something out. Let's get you out. Let's get you out of here. 2, cash for keys. So now, one thing they probably haven't asked this seller to do in California was, I know I paid you $565,000 to vacate or to sell, and now you're not vacating, and I can spend $50,000 in attorney's fees and eventually get you out of here in a couple of years. But what if I just give you 20 grand to leave? That sounds awful. It would almost offend you to feel like you have to offer it 20 grand. But imagine the impact that might have had a year ago when the buyers realize the seller is not leaving. And you say, I'll give you 20 grand to leave. Or in the very least, you say, hey, I'll give you 5 grand extra at closing if you don't do post-closing occupancy. That's pretty great. And we use this all the time in just standard leases. I'll offer you $1,500 if you vacate the property by next Friday to help you with the move and securing a new place to live. Maybe they need money. Maybe that's what the restriction is, that they haven't found another place. They don't have the deposit. Let's find out what it is. So the upside is getting rid of the tenant. The downside is paying the tenant who owes you money. Not fun. It will offend you. Deductions from security deposit. You could, if you had a formal lease and they don't leave, you can actually take security deposits to pay. But if you don't have a formal lease, if you're using temporary occupancy agreement, you don't necessarily have the right to deduct from a security deposit until the judge lets you. So there's another reason why maybe that's not the right solution, using a temporary occupancy agreement. All right, let's take another break. So let me check the questions real quick, and then we'll take a quick break. Andrew says, under temporary occupancy, can the seller pay a per diem? I already asked that. So I don't know much about writing leases and would feel uncomfortable doing that. Please give us written information on person you mentioned for us to reach out to help. So her name is Tia. She's lovely. I think, she has the same email addresses as you guys, tia.miller, I would guess, at harrynorman.com. You could ask the SHU as well, or ask your broker and they'll put you in touch with them, or email me later. Definitely do all those things. I'm more than willing to help you on this stuff because I actually coordinate with Tia. So what Harry Norman requires you do is, if you plan on doing any sort of leasing at all, they make you take a class. And you may have no plans of doing a lease until you come up across one of these things. And all of a sudden you wish you had that information. So Harry Norman offers a 6-hour CE class on leasing. It's a one-day thing. I teach 2 or 3 hours of it right at the beginning. We talk about the forms. I give you pretty practical advice. And then Tia talks about more of the practical or the administrative rules in actually doing the lease. So she is super knowledgeable. She's always on top of the housing regulations and what it's like to be a landlord. And she has all these resources at her resource. So definitely reach out to her. She's lovely, or reach out to me as well. But that's a resource. That's why you're out here, Norman. That's why everything is so great, with you guys, is you have those resources to become a better agent and to ultimately help your client. So take a look at that. Again, this is a good time for you to jump on there and do the form for the application of CE credit. It's campbellandbrandon.com/learn. Let me see if I still have it. I might. Here it is. So campbellbrandon.com/learn. I'll put it in the chat feature again. Click the link, scroll down, fill it out, writing a robust contract, fill in your information, tell us we're the most amazing things in sliced bread, and push submit, and you'll get a confirmation on that. I think that's a good time to do it. If you don't do it now, you'll have a chance to do it after class, and Susie and I will reach out to you if you have enough hours, but you didn't apply, and we'll help you with it. So I don't want you to have any anxiety about it at all. And if you want me to, I'll email you just a form that you can print out and email it back to us. So why don't we take a little break? We'll come back at 15 minutes from now. That's 12:10. And we've got a 50-minute finish to the finish line. You'll ask any questions you might have, and we'll finish up with this stuff. So take a look at take a break. And section 3, to remind you, is going to be about repair and amendment to address concern, right to request repairs, all that stuff that we are seeing in the market right now. So it's very, very relevant. So take a minute. We'll see you back at 12:10, 15 minutes from now. All right, guys, it's the last hurrah. So we've got section 3 here. So the last 50 minutes. Just to go over the requirements again to make sure you get your credit, stay logged in for the whole 3 hours. So if you came in at like 9:55, then you could leave anytime after probably 12:55, but stay at least till 1. And in fact, I would stay a couple minutes beyond what you think is the 3 hours. And, I'll let you know if there's any problems, but if you're careful, if you're conservative about it, you'll be fine. And I'll leave the class open for those who joined a little later than the 10 a.m. start class. So the last one would be completing that form online, and I've given you the link in the chat feature a couple of times. So hopefully you've already got that up and running on your system. So section 3 is repairs, amendment to address concern. And I'm just kind of let this section go where you guys need it to go, but we'll get it started out. So it's a never-ending tap dance. Either you don't want the lender to get in the way, or you need the repair to get done before moving in, or you need the money to do the repairs yourself, or you're not going to have your standard due diligence, whatever it may be. So what's the best course of action? Let's discuss. So let's assume you have options. You have your due diligence or right to request repairs. How do we actually go through it? What should be your preference? And this should be no matter what, lower the purchase price. If you can, maybe that makes the most sense because it's going to save the buyer some money over time. But the problem with that is if it's a mortgage and the repairs actually have to get done and the buyer doesn't have the cash to do it, it could be a bad spot. That may not be the right choice, but lowering the purchase price, that's probably a good option for you. Especially nowadays when, let's say you have that $500,000 deal and then the buyer goes up another 10. The buyer is going to be paying cash out of pocket to cover the difference over any appraisal anyways. So reducing the purchase price is probably not a problem because it really will put money in the buyer's pocket. Number 2, increase the seller's credit to closing costs. Obviously, if there's a mortgage, buyer needs this money to be able to do the repairs. Reducing the purchase price may not make a lot of sense, especially if there's an appraisal issue. So credit to closing costs, but there are some restrictions on that, and we'll go over that in a minute, on how much a lender will actually allow a buyer to get from the seller. Then have the seller, number 3, have the seller do the repairs prior to closing. Obviously, I'm not a huge fan of this. It gets the work done. You can verify before you actually close. All those things sound nice, but the seller is just going to do it the cheapest way they can. They're going to try and get it done quick and fast and cheap. And that may not be the best option. And the buyer may not like who they used or how it was finished or whether there are warranties involved or things like that. So preferably, let's let the buyer do the work after closing. They'll do it their way. 4, have the repairs paid at closing and performed after closing. I would say this is probably not, the least ideal. Maybe you put this as 3 and the other one is 4, but this would be the invoices are paid, but the work's not completed. And the risk there is, what if they cost a little bit more? What if they find additional damage? If we hadn't closed, maybe we could leverage the seller into doing it. But if we've already closed, the seller's gone. The seller's already paid their portion. There's no contractual rights after closing. So let's kind of identify those issues. And this is what I would call issue spotting. Our job is to spot issues, not necessarily have a solution for them, but spot the issues, bring it up, let the client decide what they want to do with it. So issue number 1 is timing. So there's not enough time to have the repairs done prior to closing. That happens a lot. The windows are on back order, or there's no lumber available down at the Home Depot, or contractors are in short supply, whatever it may be. It's brutal if we're trying to shove a closing down our throat and do it in 22 days or something, and it takes 4 days to get the inspection, another 5 days to negotiate over who's going to do what. You've got 10, 15 days to actually do the repairs, and then make sure it's right, all that stuff. So buyers of small children can't or will not do it themselves, or discover the issues at the walkthrough. That's the worst case scenario. So sellers rushed through this and they get it done. The buyer does their walkthrough that morning or the day before, and they realize, well, this wasn't done. Well, this, and the listing agent feels bad because they weren't there to double check it. They assume the seller did it all. Or the seller is like, hey, we did it. And the buyer's thinking, no, not the way we wanted it. So a buyer doing a walkthrough to look at repairs for the first time, not ideal. It's a big, big problem because you could have a major blow up and you're just not going to close. Also, the repairs not being done right. So that's what we're just seller concerns. They don't want the liability if not done correctly. Buyer concerns is that the sellers want it done cheap. Buyer wants it done correctly. It's this tap dance in a sense. Also having the cash to pay for it. So a lot of times you'll have a seller who's a little strapped and they need the sale in order to pay for the $12,000 foundation issue. So if getting a loan, reducing the price doesn't allow for the same dollar savings at closing. If you got your $500,000 purchase price and you lower it to $495,000, the buyers don't have an extra $5,000 because the loan gets reduced at the same amount. It might get you close, but it's not the full amount. So that could be something to consider. And the seller may not have the cash to pay in advance and they need the sale. So there, some difficulties, but honestly, I would tell my seller to put on your credit card. You don't need to pay in cash. Let's just get this done so that the buyer is comfortable and get it paid for, and you'll pay off your credit card when you sell. A lot of people don't even think that for some reason. And then finally, the lender. So don't want it to be an appraisal or an underwriting issue. I think the trainers over the last several years have done a bad job of kind of letting people know that, like, oh, don't tell the lender that. When I started working for Campbell and Brannon, I heard that a lot. And I think I've heard it less more recently. And I hope it's because we're being smarter about how we get trained. But the lender should be able to know everything. They really should. They should know about the personal property that's being done outside of closing. They should know about the post-closing occupancy. They should know about all the repairs. None of that should be a problem. None of it. But where it can be a problem is when it's a safety issue or a true value, true value issue. So let's say it's a roof that needs to be completely renovated or completely rebuilt, and it's $30,000. Well, $30,000 is significant enough to affect the value of the property if it weren't completed. So the lender is going to want to make sure that the roofing company where's the quote, where's the money for it, has it been paid, when is it going to get done? They're going to want to verify, is it done before, or is it done after? And that stuff can be complex. It can be a challenge, but there is no getting around the fact that they need a new roof. Lenders will get over this. They'll figure it out, but they will tell us how they want to get over it. They want you to do this, this, and this, and it covers your buyer. Because what protects your lender will also protect your buyer. Maybe pain in the neck. It may be an extra couple of steps, but if it protects the lender, it will protect the buyer, and it will keep the seller on the straight and narrow. Not give us a ton of options. Also, what we talked about is you can't give more than just the actual closing cost that the buyer actually has. So let's look over that in a sense. So beware of guideline restrictions, and this could change at any time. So, if you're doing a deal in a year or so, you got to re-verify what the restrictions are. But this is the maximum a seller can contribute to the buyer's closing costs, and it's based on the amount of the down payment and in the type of property. So the first three are principal residence or a second home. So less than 10%, the most the seller could contribute is 3%, which is actually a good amount. If you think about it, $15,000 on a $500,000 deal. Seller could contribute up to $15,000, but the buyer actually has to have $15,000 in closing costs. And that can be really tricky. I would estimate most of the time on a $500,000 deal, you have like $10,000 in closing costs, maybe 12. Maybe you have more, but that's tight. So I probably wouldn't ask for 15. I'd ask for 7. And I would make sure that, okay, what's the estimate from the lender? What's the estimate from the attorney? Okay, 7 is fine. But if it's more than that, it's tight because anything over the amount of the buyer's actual closing costs, that credit doesn't get used. Basically, this goes back into the seller's pocket. If you're putting more than 10% down, but less than 25, it's a 6%. So that's $30,000. So you put 20% down, the seller can contribute up to $30,000 in closing cost. And then more than 25%, they could do 9%, which is $45,000 in closing costs. Again, you're going to be pretty restricted on how much your closing costs actually are. And closing costs is really, it's defined by the lender. I do my best to help a lender see, oh, what about this cost? And what about this one? But it's the lender that defines it. I would say it's the closing attorney's fees, the taxes, the recording cost, it's escrows, prepaid HOA dues, all those things. It would be the lender's origination fee, it would be discount points. But some lenders will get squirrely about surveys. Maybe a survey is not a closing cost. Maybe an inspection is not, an appraisal is not. It's hard to say, but the ones I would say most likely are those original lender charges, the original closing attorney charges, and the not the property taxes, but the ad valorem taxes and any escrows that go with it. If it's an investment property, it's limited to 2%. So if you're, realize that that's an even more restrictive guideline for you. So take a look at that. And anytime someone wants to put a lot of money as a seller credit, you have to realize the lender's going to have a say in that. All right, so the lender, worth repeating, ask the lender. Ask the lender, ask the lender. Whenever someone calls me, they'll say something like this morning, I had a question. Actually, let me pull it up. It was a text message. So the question was, good morning, does this make sense? Would you word this differently? This is a special stipulation. Seller agrees to contribute $2,500 towards the buyer's closing costs for repairs. All parties agree that this compensation shall satisfy the defect concern found under inspection per the right to request repairs. And my response was it's really well written. I totally understand what it is, even without any context. I know what you're talking about, but I don't like it because the lender may not like it. So I have a suggestion. This is what I said instead. Use this instead. Seller shall contribute $2,500 towards buyer's closing costs. And we know by the guidelines that this was going to fit. This is going to be well under what the buyer's actual closing costs were. And then 2, buyers shall waive the right to request repairs. See how it kind of does the same thing? The buyer can't come back and ask for more repairs. The seller's contributing closing costs. We're not lying about what repairs are there. We're just not putting it in writing. We're just saying, hey, there might be repairs. There may not be. I don't know, but I'll contribute $2,500. And if it was more significant, if it was like a really big structural issue that needs to be addressed, we probably can't sweep it under the rug so much. But I'm not lying to the lender. I'm just not making it a point that they even have to question. I'm just saying, hey, it's $2,500 credit. It's within the guidelines. It's allowed. Buyers waive the right to address concerns, and maybe that was consideration for it. So lenders can see between the lines. They understand what's going on, but we don't need to make it that apparent. So I like that. It's waiving that contingency and adding to the closing cost credit. Hope that makes sense. So here are my preferences. Paying cash, lower the price. Let's look at what Carol's question is first. So are you as a firm, not a firm, just a person, willing to escrow funds for repairs post-closing, which are major issues such as those you're discussing, as long as it's to be completed within 30 days of closing? It's a good question. I can't hold earnest or any escrow money unless the lender approves it. So if there's no loan, if it's cash, yes, I will do it. And I will do what you said, Carol. I will put some restrictions on it. I'll try and simplify it. I'll say seller shall replace the roof and pay the bill within 30 days. Otherwise, the earnest or the escrow money goes to the buyer in full at that 30-day mark. I make it a clean break because I don't want this to have a tail that keeps wagging me for the next year. That's if it's a cash deal. I think that makes a lot of sense. If it's a loan deal, I'm going to have to take that same question and I'm going to go right to the lender. So remember what my question was, ask the lender. I honestly will do it. We love you guys. We will absolutely hold escrow money. We would prefer not to, just like Harry Norman doesn't really want to, but we'll do it. I just want to make sure that it's very tightly defined and that the lender's approved it. So I hope that makes sense. What typically would happen in that case, Carol, is I had a deal where Prosperity Mortgage did, I think they escrowed for flooring. And that's a pretty significant deal. The appraisal even said like, hey, they need new floors. This is a mess. There's no floors here. So we escrowed for flooring. And when the work was completed, the buyer gave me an invoice, said it was paid, or maybe they had, I don't remember exactly. And so what Prosperity had to do was actually send the appraiser back out, verify that the work was done, and then they would allow me to release the escrow money. Obviously, that's extra steps, but it's totally out on the open. No mortgage fraud, no discussions of issues, and the money's there to pay either the buyer or the contractor or the seller, whoever it was supposed to go to. So yeah, as a firm, we are willing to do it, but my response is, depending on what it is, the lender is going to make this really complex, or they're not going to let you do it. There are a couple of lenders who will make a point out of having a loan program that allows for escrows. In fact, I saw one from Bank South a couple of years ago, and they made a big deal about it. But when you read the fine print, it had to be requested 14 days prior to closing, and it couldn't be for like 5 different items, which took like 99% of the times you would use it off the table. Because what you're looking at, Carol, most of the time, you're going to come to me and say, hey, we did the walkthrough and they didn't complete these 3 items. Can you escrow $3,000 for 30 days? Just like we said in the class. And I'll say, probably not, because we have to go back to the lender, get a new CD, get their approval, if they'll even give it. So I hope that helps answer it. We are allowed to do it, but it's pretty restricted. Cindy says, do you mean Harry Norman does not want to hold escrow after closing for repairs? No, I don't think I would say that. I'd say for the most part, you'll ask me first. You will ask the closing attorney to hold it first. And ultimately, the way Harry Norman would need it is they would have to have separate money. The seller would have to write a separate check of 30 grand or whatever it is to Harry Norman outside of closing, which is, it's not the way you want it. So that's why Harry Norman's probably not the one that's normally holding it, but it does happen. Andrew says, could the attendees select? Yeah, you can select who you send your message to, absolutely. All right, so preferences. If you're paying cash, lower the price. We have a $500,000 deal. The seller didn't do 3 items. The total is probably $900. Let's do the deal, the new closing at $499,100. That's what I would recommend. So there's no appraisal issues. There's no lender issues. You're going to pay less in taxes. Yeah, commission would potentially go down, but there's a way around that as well. You may want to negotiate your commission based on the original price. It would be silly for a $900 change, but if it's like a $30,000 change, maybe you say, hey, you know, listing commission or commissions paid to brokers shall be based on the $500 sale price. And Cindy also asked, she's seeing listings where they instruct that the closing must hold, or the closing attorney must hold earnest money. Campbell Brannon will hold earnest money. I would prefer that Harry Norman do it, but sometimes you're working with another agent who doesn't want Harry Norman to hold it. And I think that's unfortunate, but we will hold it and we don't charge for it. If there's a loan, I would have the seller pay for the work from the closing proceeds and let the buyer manage it. So here's the potential issues. The lender may still need to approve this. This is work that's going to be on the closing statement. So the lender's going to see it. They're going to see it on the seller side of the closing statement. And a lot of lenders may not care, but if it's a list of different invoices, they're going to see it. And then also, this means the work's going to get done after closing. And we talked about that earlier. There's no way to know if this is the end, if that's going to fix it. But the upside is the buyer can control it. The buyer can contract with the contractor directly. You are going to need invoices though. So, you know, if it's an HVAC, we need an actual invoice that we can pay at closing. I can't just do it on an estimate. It would need like a bill, something that I can pay. But the upside, you don't have to do it prior to closing. You don't have walkthrough issues and all that stuff. And then finally, buyer repair items or seller repair the items. So buyer best only if buyer has the funds to do so. So if you can reduce the price and the buyer will just pay out of pocket because they have the extra cash, let's do that. Let's reduce the price, save money over the long term. You could, if you were going to put 30% down, now you only have to put 20% down and use that extra 10% to do your repairs. And then for seller, best and the worst case scenario, do this first, right? If the seller has no other option but to get the work done prior to closing, just make sure it's done as soon as possible and that you have pictures and invoices for every item and you're checking it off. Okay, well, what about this? Well, what about, because ultimately, if they do a walkthrough, the buyer's broker is going to call you and they're going to say, hey, your seller didn't do X. And you just need to be prepared. You need to know that before the call. I think that's the most important thing. So it is a proving imperative that we also consider property sold with right to request repairs exhibit F273. F201 provides for due diligence period, which we went over in section 1, allowing the buyer to terminate for any reason, aka a free look. The repair exhibit, however, limits that right only if a certain repair will not be addressed by the seller. How does this work? When should you use it? Should you use it? I did a whole class on this topic, so we'll do a condensed version of it. But actually, before we go to it, everyone thinks the right to request repair is just better for the seller. And I'm going to make a point to you today in the next 10 minutes that maybe that's not the case. Maybe a seller should still ask for due diligence, and I'll let them be the decision makers on that. But let's look at it. Let's think about it. And I would love your comments. Keep giving me the chat stuff. So first, look at the due diligence period. As a recap, using Section 8 allows the buyer a number of days, 10 days, 7 days, 5 days, to unilaterally terminate without penalty, aka a free look. The basis for this right is found in section B8D of 201. If you haven't read this before, this might actually be very enlightening to you, because it's every week I get an email asking, can you give me a stip that says the property is being sold as is? And I give it to you. That's fine. But look at this section. It says, property sold as is unless this agreement is subject to due diligence period. The inclusion of a due diligence period herein shall, A, during its term, make this agreement an option contract in which buyer may decide to proceed or not proceed, and B, be an acknowledgement by seller that buyer has paid separate valuable consideration of $10 or that extra amount, if you used option money, for granting of the option. Look at this, the purpose of the due diligence period. So it actually, even before that highlight, it says the property shall be sold as is with all faults. Even if the property is sold as is, sellers required under Georgia law to disclose to the buyer latent or hidden defects in the property, which sellers are aware and which could not have been disclosed. So there's your seller disclosure. And it keeps saying, unless it's being sold with the due diligence period, but it's still as is. No matter what, even if a due diligence period is included, and don't get caught up in the language. It's just the contract is distinguishing that, hey, they have this free look, and if they want out, they can. But it's an as-is contract. The seller is agreeing to convey the property in the same way it was at the binding agreement date. So let's look at section D2, purpose of due diligence period. This is a part a lot of people don't even realize is in here. During the due diligence period, buyer shall determine whether or not to exercise the buyer's option to proceed or not proceed with the purchase of the property. This is where sellers might get freaked out if they kind of thought this was something else. It says, if buyer has concerns with the property, buyer may, during the due diligence period, seek to negotiate an amendment to this agreement to address such concerns. The contract is actually telling the buyer to renegotiate if there's something you didn't realize. That's crazy. A lot of sellers don't think that. And that is the purpose of the due diligence period, to make sure that everything the seller told you about, everything you thought you knew about the property based on the listing and your initial visit to the property is accurate. But if there's something that you didn't know, that you had to do your inspection to find out, the contract's telling you should renegotiate. I think that's awesome. I really think that's awesome. Number 3, notice of decision not to proceed. If the buyer doesn't want it, buyer notifies seller of buyer's decision not to proceed by delivering to seller a notice of termination of this agreement, unilateral. In the event buyer does not terminate this agreement, then the buyer shall have accepted the property as is. So this is where I'm telling you, even if it's subject to due diligence period, still as is. So this is section D3 at the bottom. Buyer shall have accepted the property as is, subject to the terms of this agreement, and buyer shall no longer have any right to terminate this agreement based upon the due diligence period. That's really interesting, right? It's as is already. You don't have to add something in there. But go ahead and put in the chat feature, what's the upside of adding that as a stip? I'm already going to tell you it doesn't really change the contract at all, because it's already saying that the buyer shall have accepted the property as is, subject to the terms of this agreement. It's already as is. What's the purpose of putting the stip in? What's the upside? Because there is one. I think there could be. It's the reason why I give people this as opposed to trying to tell them not. Clarification of what, Nancy? Clarification to all parties, she says. Of what? What are we trying to clarify? Oh, Robin, you're yelling at us. As is, that's right. So Nancy's saying it's clarification to the buyer specifically that the seller is not going to fix anything. The seller's not interested in renegotiating. It's just kind of trying to set the stage. I'm sorry, I was just picking on you, Robin. Cindy says, make it obvious to all parties that might otherwise overlook the fine print. I agree with that. Just to reiterate for the parties. Yeah. So, and Robin says, so the sellers really see it and take not. And if the agent isn't good to explain, yeah, that's true. I think it's the seller setting expectations. That's what it is. It's saying, hey, look, you have this due diligence, and maybe customarily you use this opportunity to renegotiate. But if you come back to me, I'm not repairing anything. And unless you call my bluff, you're not getting anything else out of me. That's why people do it. I ignore it, honestly. When I bought my house in 2017, the seller wrote on there, it's as is. Well, guess what? When I did my due diligence, I had them spend another $7,000 on, there was like mold remediation, a new HVAC, and some new windows. I mean, it might have even been more than $7,000, because otherwise I'm walking. And he could have called my bluff, but I wasn't bluffing. So let's see if there was one other question. All right, so did you know, despite what some sellers may believe, the form encourages buyers to renegotiate if during this period they discover issues with the property not previously disclosed or understood. I always recommend, and we just talked about that, but you should make an offer based on all of the information you have available. I don't think it's appropriate to know that the house needs a roof, make a full price offer, knowing that a couple of days later, you're going to come back and request a new roof. You had that information initially. I think that's kind of disingenuous, and you're going to waste your money doing it, honestly. But if you go into this property and the seller had told you the roof was brand new, and you find out, no, it's not, this is messed up, you're lying to me, then you're going to renegotiate, or you're going to walk. Maybe you should just walk. Special note, if you haven't done a new construction contract before, they do not have due diligence periods in new construction contracts. Whole nother class on stuff like that, but just realize that, if you're buying new construction, there is no walk away period for any reason. Robin says, so when all else is said and done, is it stronger in multiple offers to do typical DD or right to inspect with no repairs? Let's keep going. Let's think about that. So here's your form. We talked about due diligence period. I talked about why I like it in a sense, but you can really only understand why I like it as compared to what our alternative is. So property sold with right to request repairs. This is exhibit F273. Buyer shall have the right to request that seller repair and or replace defects in the property, if any, within a certain number of days of the binding agreement date. Buyer shall provide seller with a written amendment to address repairs and a copy of the inspection report. And you might see 3 days on there, you might see 10 days. So in that time period, the buyer has to get an inspection, has to give that inspection to the seller, and has to give an amendment to have the seller address defects. That's a little backwards from what we've always done. I mean, how often does a listing agent tell us, I don't want to see the inspection report? So just remind it, if you're agreeing to the right to request repairs, they have to give you the inspection report. If your buyer chooses not to get an inspection, which is pretty rare, but let's say it's an investment property and you do the right to request repairs, well, guess what, buyer? That contingency means nothing if you don't get an actual inspection. Keep that in mind. That's maybe unusual, but it happens. If not agreed during this time, so the buyer submits this amendment with the inspection. Buyer and seller shall have blank days from the binding agreement date to attempt to negotiate. Buyer sends this amendment. Seller says, well, I'll only do these two things. Or in fact, on another text message this morning, I said, don't, I think it was actually before this text message this morning, it was last night. I recommended that the agent not do the repairs. Because remember, I said in a couple slides ago, don't do the repair, just give money. I don't care what the right to request repairs form says. I don't want you to ask for a repair. I want you to ask for money. So when the seller gets this right to request repair, if the buyer hasn't asked for money, then the seller should offer it. Hey, what if we negotiate? I don't want to do the repairs. Let's do cash. Let's do $2,500, just like that text message said. They have so many days. Let's say it's 7 days, because it's a little better than 10. If the requirements of the preceding sentence have not occurred, basically if they haven't signed that amendment or negotiated on a final price before the end of that 7-day period, then within 1 day thereafter, the buyer or seller may accept in writing the other party's last written offer or counteroffer regarding the repair, owner replacement, or buyer may accept property in as-is condition. Actually, I think I skipped a part on this one. This section 2 is in reference to an extension to negotiate. So if we look on the first part, it says that you would put 7 days here. Within 7 days, they have to submit this amendment. And if they haven't done so, buyer has an additional number of days to figure this out. They call it the defect resolution period. If they can't figure it out, then the buyer has some options, the seller has some options. If neither party timely accepts the other party's last offer or counteroffer, or buyer does not elect to buy the property as is, this agreement shall terminate. So if not agreed during this time, buyer or seller may accept the last available amendment. The buyer can accept it as is, or the agreement automatically terminates. I don't know if that's what we want. It's so different than due diligence, but that's the way it's written. Let's keep looking at this. If the inspection report recommends further testing, aka mold testing, radon, maybe an HVAC specialist review, almost every inspection report I see says contact a professional for further analysis or something. So the inspection report says almost 100% of the time that the buyer needs to follow up with a licensed professional. Then the buyer can extend the repair request period an additional 7 days. Look at that in highlight there. Buyer defect resolution period may be extended once by buyer upon notice for up to 7 additional days. So now we thought we had initially a 10-day due diligence, and now we're going to make it a 7-day right to request repairs that all of a sudden gets moved into a 14-day right to request repairs. That sounds brutal. All of a sudden we've made this so much more complicated, so much more complicated. There's a whole lot more that we can talk about on this form, but the most important thing is, what is a defect? What does the buyer have the right to ask the seller to fix? Because it's not just cosmetic stuff. In fact, that'd be something the buyer can't ask for, or they can't get out of the contract for asking for it. So let's look at it. The term defect shall mean any infestation by termites, insects, or other wood-destroying organisms, or portion thereof identified by inspector in a written report, which, 1, is a condition which represents a significant health risk or an imminent risk of injury or damage to persons or property. Health risk or safety risk. So they're saying if the inspection report says that the deck is not secured properly, is not structurally sound, or is not to code or something like that, and it ends up being a safety issue, then the buyer can request the seller fix it, and if the seller won't, the buyer has those remedies to terminate. Or 2, constitutes a violation of current laws, zoning laws, things like that, except if it is grandfathered in. But remember, if it's that deck, If it's a safety risk, I don't care if it's a code violation or not. I don't care if it's grandfathered in or not. If it's a safety risk, the buyer can still ask for you to fix it. Or 3 is not at the present time in good working order and repair, except normal wear and tear. So if the dishwasher breaks, if it's not working, if the HVAC is not working, the buyer can make the seller fix it, or at least ask them to fix it, and then they'll have the remedies, which is not what due diligence would be otherwise necessarily. It would be more of an open invite. So I can almost guarantee you that on 95% of inspection reports, the buyer will find something that meets one of these standards. Unless, and this is a really important part, and I hope we all use this. Look at that bottom piece that's highlighted. And notwithstanding the above, all parties agree that if the existence of a particular defective product has been disclosed by the seller in the property disclosure statement prior to buyer contracting to purchase the property, then that defective period or any portion thereof shall not be considered to be a defect if at the time of the inspection it is functioning in accordance with the manufacturer's specs and is reasonably fit. So they're doing a carve out, saying unless it's disclosed, you knew about it, you made an offer anyways, and now you're asking me to fix it. Doesn't work that way. So it's a complex form. This is a weird, difficult form. Typically, if we think about it, the questions that are going to come up are more in line of, can they ask for that? And I don't really know. This is tough. I think a buyer could ask for anything. And now the seller has to figure out, do they have the right to ask for it? And if I say no, do they have the right to the earnest money? That's really what's at bay here. I think the buyer should really just ask for anything. Send them the inspection report, tell the seller they need to fix everything and see if they get lucky. And if the seller later walks away or says no, then we have to figure out, okay, did the buyer actually have the right to ask for all that stuff? Julie says, if you have a buyer and use this, shouldn't they make sure they get earnest money back if they can agree or can't agree? Yeah, that's kind of my point. We can ask for it. This, we'll go this whole, tap dance, but the reality is you're probably going to go through each line item and say, which ones meet the defect note? And actually, I've told a listing agent this previously because they got like 30 items that were shown on the inspection report, and the house needed some work, so they weren't necessarily surprised by it. But I told a listing agent, go through each item and put a little asterisk on the ones that are technically a defect given this definition. And then tell the seller, say, hey, look, here are the 6 things that are a defect that the buyer actually has the right to request. Otherwise, they would get their earnest money back. So let's do those, and then let's ignore the rest, and we'll look great. We got a great offer, above listing, and we're going to do some of the work, even though maybe we don't have to, or we have other offers, but we're going to look like good people. We're going to do the right thing, or actually, what we're going to do is we're going to give them some money, and that's what we did. That was kind of the resolution of this text message from this morning, is that there were 30 items. We identified 5 or 6 of them that were defects, and the seller agreed, all right, let's put a number on that, let's offer it to the buyer, see if they'll go for it. There was also a termite thing in that, which would be also another defect. So I hope that's helped. So it says, where does it say they get their earnest money back? So it says it in the form. Basically, the buyer has the right, it's a contingency, and if the seller doesn't do this, then the buyer gets their money back. Let's see it. In fact, it says, I think it says it up here. Buyer or seller may accept in writing the other last final agreement. So if neither party timely accepts the other party's last offer, or buyer does not elect to buy property as is, this agreement shall terminate. Well, it's terminating per the contingency, and a contingency means that the buyer gets their earnest money back and you're not in default. So we talked earlier about how reading one sentence is pretty straightforward, but tying it into the rest of the contract can be pretty challenging. In this case, you would actually say, all right, this agreement terminates per a contingency, which under the default language in the purchase and sale agreement says it's not a default. It did not meet the definition of default. So that's where it says it. Would I love for this exhibit to say that the buyer gets their earnest money back? Sure, that'd be a lot simpler, but it just doesn't. It just doesn't. So here's some examples. Termites, a broken appliance, missing handrails on a deck or something, or on a porch, not defect items, broken HVAC, which was previously disclosed, or old electrical that was coded at the time of installation does not pose a safety risk. Maybe you could claim that it does, but if it's not, it's not. Problem areas that I could see were code violations that were coded at the time, so it's technically grandfathered in, but that also represent a safety risk. This is, if I was the buyer, knowing what my wife and I think about and our 3 kids, I remember seeing a deck and it was 6 inches apart. At the time, that was code. It was early 2000s. It was a code. It was within code to be 6 inches apart. Well, fast forward 20 years, and that's no longer code. Code is 4 inches apart because they didn't want kids to be able to stick their head through it and potentially get stuck or fall out, go overboard. That'd be bad. So they updated the code. Well, why did they update the code? They updated the code because it was a significant safety hazard. The seller could argue with me. I'm just hypothetical here. I could see me making that argument. Well, hey, it's a safety issue. We take that very seriously. I've got 3 little kids. I'm going to have to fix that because it's not significant. So I'm going to make you fix it. If you won't do it, I'm out. And the seller could argue with me. No, you're not bullying me out of this one. It's not a safety issue. I've had kids here all the time. It's not a problem. You can't fit your kids' heads through there. And I don't know what to tell that seller, but that's what I would argue. And you can see how challenging this could be. And that's a pretty simple, easy issue. Pretty complex. So which one's the right one for you? Obviously, it's not you making the decision. It's the buyer or the seller. The fact is that most sellers and their broker believe that the right to request repairs exhibit is more favorable to the seller than the standard due diligence period. That's just the perception. That is exactly what sellers think. But is that really true? As always, it depends on the circumstances. The pros of it: limit the issues the buyer can object to while eliminating the free look. Establishes the mindset in both buyer and seller that they are obligating themselves to addressing any defects. 3, forces the buyer to get an official inspection. 4, encourages the seller to disclose. You're the listing agent. You're like, hey, seller, if you disclose this stuff, it takes more and more power away from the buyer. Let's disclose. Let's make sure it's on there. The cons of this: parties could still argue over whether an item is a defect. Yeah, it's a pretty big con. It's pretty gray. It's a gray thing. 2, 7-day extension could ultimately extend due diligence further than what you would normally agree to under due diligence. So would you rather have a 7-day due diligence and that day 8, or do you want it to potentially be a 7-day right to request repairs and that gets extended another 7 days because they needed a radon test? That's ridiculous. Come on. Custom suggestions. So here's what I might suggest. You could stipulate that the 7-day extension is removed, require any request be submitted with an invoice. So you say, if you're going to submit a request for a repair, that you submit an invoice with it, that we know exactly what we're talking about. Let's put more onus on the buyer to come out with actual information that this is wrong. Or then ask the lender if you can instead ask for a credit in lieu of repairs, the way we were talking earlier. That, are you within the guidelines? Do you have that many closing costs? The end? So abrupt, but yes, that is the end. That is the end. So we've got a few minutes to do kind of a question and answer. I was thinking we could even look at some of the forms if you wanted to, but Vanessa says, what about the FHA required repairs? The home is as is, the seller obligated to pay the FHA required repairs. Yeah, they can be. So an FHA appraisal or a VA appraisal will include safety items, which kind of correlate well with the right to request repairs. It's kind of similar language. And if the appraiser lists something like a handrail, so they would list something like the 6 inches needing to be 4, or adding a handrail. It tends to be the handrails that show up on those appraisals more often than not. And so the lender is going to require it. And they have all the way through closing to require it. And otherwise, it will fail the FHA or VA contingency and the buyer gets their money back, no matter what the dates are or any of that stuff. So yeah, FHA required repairs would obligate a seller up to a certain dollar amount. So if you remember those contingency exhibits where it talks about required repairs, it says how much the seller will agree to address automatically. And anything over that would allow the seller to terminate. So yeah, you have to put a number in there, but if you put 0, the seller's not obligated, but the deal could terminate without an actual closing. All right, can you go back to the last pros and cons page? Yeah, of course I can. Absolutely. Well, what else can we talk about, guys? We got about 5 minutes. I want to make sure that you have logged in and done your application at this point. You should have gotten a confirmation, but it's campbellbrandon.com/learn. If you look in the chat, you should see the slides. You should see all of that. My email is cross@campbellbrandon.com, or the shortened version of it, which you can use for anyone in the firm, first initial, last name, @cb.law. Feel free to email me. I may not get to you right away because I have to catch up on my actual emails just like the rest of you do. But this is a really fun class. I'm glad this was the first time and teaching it with you guys. You asked wonderful questions, and I really appreciate that. But this is something that's going to change all the time. And so, don't say, well, Christian said this 2 years ago that, you should do this. Let's just adjust, and let's continue doing these learning sessions and classes, and make sure that we're paying attention to what everyone's rights and responsibilities are, and then what are the remedies if they don't? What happens if they don't? Alex asked, so just to make sure I was clear with the right to request repairs, if there's something that comes up to repair, there's an auto extension to make sure that gets repaired. No, there isn't. It's in regards to the ability to get a follow-up inspection if needed. So if something lists on the inspection needs further examination or another report or something, and it's listed in the report, then the buyer can actually can extend the right to request repair timeline. It's such a weird thing, and I know it would just infuriate sellers, and hopefully you'll never have to deal with that. But it doesn't extend closing. It extends the right for the buyer to inspect a certain issue that would be addressed on the original inspection report. Susie says that she's received 35 class applications already, which is awesome. That's about half of you. If you are not wanting credit, you don't have to, or if you wanted to put it on there, wouldn't hurt. But we'll do a search. Susie and I will get a report of everyone that was listed. If you hit the 3-hour minimum, we'll make sure that you get your credit. Just give us a little bit of leeway. It might be a week or so before everyone gets their credit. But if you notice that you haven't gotten it, by the end of April or something, then you can reach out to us, and maybe we made a mistake. Not that ever happens. But again, this is a fun class, and I love teaching it to you guys just in general, but this class particularly is really relevant. So I hope that you got something for it, even if it was just 1 or 2 things. But like Susie was talking about, make sure that if you haven't already, fill out your application online. And I'll keep this class open for another 10, 15 minutes. And but if you need me, call me, okay? Call anyone you want at Campbell Brannon. We would love to help you. So I wish you the luck. Thank you so much for being so good to me and participating, because this isn't the easiest thing in the world to be staring at a computer screen or a monitor the whole time. So good luck. Call me if you need me. Bye, guys.